All right. All right, and with that, I now have entries. It appears both parties are ready to proceed. Before we call the case, if I could have everyone please raise your right hand. Please indicate by saying "I do" if you swear to abide by the rule of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
Okay, we'll now call the case number 082263. That is Cam Donaldson versus Karen Beja. We do have entries of appearance from the plaintiff and the defense. Are there any housekeeping matters first looking to the plaintiffs?
Yes, Your Honor. May we assume that all witnesses are pre-sworn?
That's fine. That'll be granted.
The exhibits are not pre-marked. May we refer to them by their page number when identifying them before marking them?
Prior to marking them, yes. However, once exhibits have officially been entered or when they are tendered, I would like them referred to by their number or letter.
Yes, Your Honor. Also, when identifying those exhibits, would Your Honor like for us to drop a copy of the exhibits in the chat, or are we okay to just refer to the appropriate page number?
I will leave that to your preference. If you want it to be in the chat and have it readily available to me in that way, that's fine. If you want to refer to a page number as well, I can do it that way, whatever your preference is.
Yes, Your Honor. Your Honor, pursuant to local rules, co-counsel may perform the role of trial technician. As such, Ms. Sims is going to be handling the screen share responsibilities for me during my closing argument and examinations, and I'll be doing the same for her during her open and examinations.
That'll be granted as well.
And Your Honor, if it becomes necessary to mark an exhibit for demonstrative purposes only through the annotations feature, may we ask the witness to do the marking?
That's fine.
And there are certain stipulations contained in the file on page 9. May we read those to the jury when they become relevant?
That'll be granted as well.
Would you like for us to formally tender our expert or lay the foundation and move on?
Formally tender would be appropriate.
Because we are not in a courtroom, may we ask to be heard outside the presence of the jury for any kind of sidebars?
Certainly.
And may we assume those sidebars are constructed for the benefit of the scoring judges?
That'll be granted as well.
And Your Honor, normally we would invoke the rule. However, all witnesses are either parties or experts, and therefore we will not be invoking the rule.
Okay. Typically what we would do is we would just constructively sequester all witnesses for the purposes of this proceedings. However, I do understand, given the practical matters of how we're doing things this time, they will technically be present.
Yes, sir.
Any further housekeeping from the plaintiffs?
Yes, Your Honor, just a few more. Your Honor, we remind the court that this trial is not bifurcated and therefore we must prove damages.
The court will note that.
And lastly, we have agreed with opposing counsel to exclude the pictures of the airplanes and the water found in the electronic record on pages 61 and 62.
That was the airplane and then the water you stated, the debris in the water?
Yes, Your Honor.
Okay.
And that concludes our preliminary matters, and we are ready to proceed with motions in limine.
All right. Before we get to the motions in limine, are there any further housekeeping matters from the defense?
Yes, Your Honor. Before we move on to those preliminary matters, may my co-counsel tender our notice of appearance to you now via chat?
Certainly.
And if you'll just let us know whenever that goes through for you.
I've received that.
Perfect. May I proceed with my preliminary matters then?
You may.
Your Honor, we request that we be able to enter in evidence during opposing counsel's case in chief due to our inability to call rebuttal witnesses during these proceedings.
That'll be a case-by-case specific request depending on if there's proper foundation, but the court will take note of your request and we'll take it up when the evidence presents itself.
We would also just put the court on notice that it was our plan to refer to exhibits as we are entering them before they're entered by the last 2 digits of the Bates number at the bottom right-hand corner of the page. So while we don't have the electronic page number marked like opposing counsel does, that's what we'll be referring to beforehand.
Okay, thank you for letting the court know. Anything else?
No, Your Honor, with that, we're ready for motions in limine.
All right, we'll turn to first the plaintiffs for motion in limine, keeping in mind that you have 4 minutes to present your motions and 4 minutes to respond to opposing counsels. So starting with the plaintiffs.
Yes, Your Honor. This is a wrongful death case in which we are suing the defendant for intentionally or recklessly causing the death of Lou Donaldson, Cam Donaldson's father. Lou Donaldson was last seen alive by his daughter on August 17th, 2012. The defendant petitioned to have Lou Donaldson declared legally dead on August 18th, 2017, and plaintiff has 1 motion in limine.
Okay, proceed with your motion.
Your Honor, plaintiff moves to exclude any mention of an alleged mistress of Mr. Donaldson. The defendant claims that Mr. Donaldson told her that he had a mistress in Costa Rica. Specifically, on page 44 of the record, the third answer on that page, the defendant stated in her deposition, he had a mistress in Costa Rica. It is something we had spoken about and were working through. Therefore, plaintiff moves to exclude any mention of this mistress as hearsay.
Okay. Are there any further motions in limine from the plaintiff?
No, Your Honor, that's it.
Okay. Before moving into the defense's motion in limine, let's start with responses to the people. Any response from the defense?
Yes, Your Honor. I would argue that we won't be using the existence of this mistress in Costa Rica. It won't go for the truth of the matter asserted. It will simply go to the effect on the listener being the investigator in this case, who learned of this possible other location of Mr. Donaldson and did look into that possibility. And so we would ask that we be able to get into the existence of that mistress.
All right. At this time, the court is going to deny the plaintiff's motion to exclude any mention of the alleged mistress as to it being hearsay. Please feel free to renew your objection at the time of any testimony coming in. There may be some foundation required. However, at this time, looking at things in a vacuum, the court does not have enough information to simply exclude any line of questioning as it may pertain to the existence of an alleged mistress. The court is mindful of the defense's argument of why this information will be admitted as well, based on the effect of the listener on the investigator. So the court will be mindful of that when the evidence does come up. All right, seeing as there were no further mills from the plaintiffs, let's turn to the defense. Are there any motions in limine from the defense in this case?
Yes, Your Honor. I have 2 motions to bring before the court today. The first being that we move to exclude any mention of statements purportedly made by Miss Samantha Lane. By way of background, Miss Lane was a witness to Mr. Donaldson's last will and testament, which is at issue in today's case. We expect that the plaintiff will try and bring in statements that she made purportedly to their own investigator witness and also to the defense's investigator that call into question the validity of her signature on that will. And because Miss Lane is not testifying today, any mention of these statements would be inadmissible hearsay with no recognized exception.
Okay. And why don't you proceed with your second motion as well before we get a response from the plaintiff?
Yes, Your Honor. The defense moves to exclude any mention of the request for temporary restraining order that Mr. Donaldson sought against his wife pursuant to rules 802 and 404. By way of background, 2 months before Mr. Donaldson disappeared, he filed a request for a temporary restraining order against his wife, our client. Because we anticipate that the plaintiff will try to bring in this order to try and prove that Ms. Baja was involved in Mr. Donaldson's disappearance. And the order and the allegations contained therein are inadmissible hearsay and would also constitute improper character evidence. Further, because a judge denied and dismissed this order, its admission would violate the principle of res judicata.
All right, thank you, counsel. Anything further?
No, Your Honor.
Okay. All right, any response from the plaintiffs?
Yes, Your Honor. Regarding Samantha Lane's letter, under Federal Rule of Evidence 705, the expert may be required to disclose those facts or data on cross-examination, which the expert has considered. Mr. Renard, the insurance investigator, he clearly considered this letter and he disregarded it, but it was still factored into his opinion. and therefore we are allowed to cross-examine him under 705 based on that. And then also it goes to the credibility of his investigation, which is Rule 611. So would you like for me to move on to the second argument for the temporary restraining order?
Yes, please, counsel.
Yes, Your Honor. Your Honor, Mr. Donaldson was declared dead and therefore is not available. Furthermore, we have alleged and will prove that the defendant wrongfully caused his death. As such, pursuant to 804B6, Mr. Donaldson's petition for a restraining order is admissible as a statement offered against a party that wrongfully caused his unavailability. As Your Honor knows, this rule recognizes that a party forfeits the right to object on hearsay grounds when the party's deliberate wrongdoing caused the unavailability of the declarant, and that the party's wrongdoing does not need to consist of a criminal act. Here, the defendant's wrongdoing caused Mr. Donaldson's unavailability, and therefore this petition is admissible.
And counsel, I understand your response to the hearsay portion of the motion. Do you have any response to the 404B portion?
Oh, yes, Your Honor. It goes to prove motive and lack of accident.
Any further offer of proof you want to provide to the court as to how the existence of a restraining order provides any evidence of motive or lack of accident?
Yes, Your Honor. In the restraining order, it clearly says that the defendant threatened him and threatened to kill him, that the defendant wanted a divorce, and that Mr. Donaldson was scared of the defendant. Therefore, this is being used to prove notice and motive because any reasonable person would know that if your husband is about to divorce you, then they're going to cut you out of your will, which would provide the motive for you to go kill him and take your whatever you wanted to do. And that's what we're arguing.
Okay. The court has undertaken argument from both parties in regards to the defense's motion in limine. In regards to the first motion in limine, specifically to preclude the statements made by Ms. Lane, at this time, the court is going to deny the motion. However, this is something that I perhaps see us retaking upon the time where this evidence is being admitted, understanding the court is going to require some particularized foundation in order to get into those statements. With the proper foundation, this evidence could become relevant. However, that is going to depend on the foundation. So this is not to be taken as a blanket ruling that is evidence that the court will hear, just that it is evidence the court could hear. In regards to the second motion, the court is going to grant this request. There shall be no mention of the request for a temporary restraining order in this case. I find that under Federal Rule of Evidence 404B, that this would be unduly prejudicial to the defense's case. I simply cannot see enough relevance that a prior temporary restraining order was in place rises to the level to allow the jury to hear evidence of motive or lack of an accident. I think that the prejudice this information could cause is far outweighs any probative value that it may have. So that shall be excluded under Rule 404B. Before we proceed, are there any further issues that the parties need the court to hear?
Your Honor, I do have one quick question that probably should have been addressed in housekeeping matters, so I apologize.
Sure.
Whenever counsel is not doing an examination or would be objecting, is it okay if we turn off our mic and video to cut down on distractions?
That would actually be the people's request. Thank you for bringing that up, counsel. If you are not one of the active participants, that is being either myself, the person doing the examination, or a witness, the court would ask that everyone turn off your video at that time. The way we are set up right now is you're only those speaking and have a camera on should be present on screen, should make it easier for anyone who's watching at home as well. Okay, and with that, yes, go ahead.
May we ask the witness about the contents of the temporary restraining order without admitting it, or is it just absolutely no mention?
At this time, the contents of the restraining order shall be excluded as well. I find that the restraining order itself, not simply admitting it, but talking about it, is something that would be far too prejudicial. Additionally, prior to admitting an exhibit such as that, talking about its contents on the stand would be improper.
Yes, Your Honor. So any mention, even if we ask the witness if there was a restraining order, we can't do that.
Correct.
Thank you, Your Honor.
Okay. And with that, we will proceed to opening statements. Opening statement for the plaintiff.
Yes, Your Honor. When faced with losing everything, some people will do anything. When this defendant was faced with losing everything, she did the wrong thing. She killed her husband to keep her status. Killed her husband to keep his business. Killed her husband to keep his money. The defendant's husband was Lou Donaldson, a self-made man who built himself a fortune from the ground up. Mr. Donaldson's true passion was always animals, especially big cats like lions, tigers, leopards. That's why Mr. Donaldson opened a big cat sanctuary called Wild Life, where he worked side by side with his only child, his daughter, Cam. I'd like you to meet Cam right now. Cam, will you please turn your camera on? For 20 years, Cam worked side by side with her dad at Wild Life, scheduling his meetings, managing the office, running the books. Cam and Mr. Donaldson shared that special bond between a father and a daughter, a bond that only grew stronger over the years as they worked side by side together. Thank you, Cam. You can turn your camera off now. Mr. Donaldson met the defendant one night when she was out hitchhiking. He pulled over, picked her up, and they had a one-night stand. The defendant was a younger woman, a much younger woman, 20 years younger than Mr. Donaldson, who admits that she came from nothing. But now that she had met a rich, older man, she was not going to let him get away. And she convinced Mr. Donaldson to marry her. But by the summer of 2012, the defendant's marriage was in trouble. We will call Cam today to tell you about just 2 weeks before her father's disappearance, she heard screaming coming from her dad's office when her father told the defendant he wanted a divorce. The defendant was furious. Screaming, she threw open the door and stormed out of Mr. Donaldson's office. Lou Donaldson was not going to take everything away from this defendant and put her back on the streets. Moments later, Lou Donaldson came out of his office. He was upset, scared, and shaking. Looking over at Cam, Mr. Donaldson said the words Cam will never be able to forget. If anything ever happens to me, be sure to have the police look into Karen. She will be the one responsible for my death. Just 2 weeks later, Lou Donaldson disappeared, never to be seen again. We brought this case on behalf of Cam Donaldson against the defendant for the wrongful death of Lou Donaldson. As the plaintiff, we have the burden today of proving to you that Lou Donaldson is dead, the defendant caused Lou Donaldson's death, and caused Cam to suffer injuries as a result. I will be the first to tell you, Lou Donaldson's body has never been found, which means that this is a case based on circumstantial evidence. But you will learn today that the law makes no distinction between direct evidence and circumstantial evidence. Therefore, we will show you through several circumstances that will prove the defendant killed Lou Donaldson. Starting with the last time Cam saw her father alive. On Friday, August 17th, 2012, Mr. Donaldson was leaving the office for the weekend, and he invited Cam over for Sunday dinner. Mr. Donaldson did not tell Cam that he was leaving or going on a trip or flying away on one of his planes. He planned to be in town. But Cam never got to have that dinner with her dad. Instead, Cam had to respond to a burglary alarm that went off at the Wild Life office early Sunday morning. It was around 6 a.m. when the alarm went off. Cam immediately drove over there with the police right behind her. Cam will tell you what she saw when she got there. The lock on the front gate had been cut off, the back entrance broken into and destroyed. And then the defendant came outside, holding a lockbox in her hands, with a man Cam had never seen before. And that man was carrying a pair of lock cutters. The police tried to question the defendant that night about the burglary, but the defendant told the police, "I'm the owner of Wild Wild Life. If you have any questions for me, contact my attorney." The defendant was claiming to be the owner of Wild Wild Life before anyone even knew Lou Donaldson was missing. Now, since he disappeared, the defendant has claimed Mr. Donaldson must have flown himself off to Costa Rica. But we will show you that the defendant's actions the weekend of Mr. Donaldson's disappearance prove she knew Lou Donaldson could not come back home. You see, just a few days after Lou Donaldson's disappearance, the defendant fired Cam from Wild Wild Life. Before Mr. Donaldson could have returned from Costa Rica, before an investigation into Mr. Donaldson's death and disappearance could have ever been completed. And then, a few days later, the defendant produced what she claims is Mr. Donaldson's will. We will show you today that the circumstances around that will prove the defendant killed Lou Donaldson. First, the lockbox that the defendant carried away that night at Wild Wild Life, it contained Lou Donaldson's actual will. Cam has not seen that will since. Second, the will produced by the defendant left everything to the defendant, leaving nothing for Lou's only child, Cam, his only child that he worked side by side with for 20 years. Third, we will call Taylor Pride, who is a forensic document examiner and is trained to detect forged signatures and has investigated hundreds of wills. Mr. Pride will tell you that in his opinion, the will produced by the defendant was not signed by Lou Donaldson, and that will is a forgery. Lastly, Mr. Pride will tell you that this will contained language he has never seen before. Language that left the defendant Mr. Donaldson's entire estate should he die or disappear. We will also show you that this defendant, she had the means to dispose of Mr. Donaldson's body. At Wild Wild Life, they use a meat grinder to feed the cats. This meat grinder is big enough to grind up a cow or dispose of a human body. This meat grinder is so big that it takes 2 people to even use it. And you will learn today that in the early hours of Sunday, August 19th, the defendant was not alone. At 3 a.m., just a few hours before Cam saw the defendant with a strange man at Wild Wild Life, the defendant was with her brother, who is a deputy sheriff at the same sheriff's department that investigated Mr. Donaldson's death. We will show you the threats, the burglary, the defendant's actions the weekend of Mr. Donaldson's disappearance. This defendant had the means, opportunity, and the help to dispose of Mr. Donaldson's body. All of the circumstances that prove she killed Lou Donaldson. When faced with losing everything, some people will do anything. When this defendant was faced with losing everything, she did the wrong thing. The defendant is responsible for Lou Donaldson's death. Find the defendant responsible.
Thank you, counsel. Opening statement from the defense.
May it please the court, counsel, members of the jury. When business owner and multimillionaire Lou Donaldson disappeared, he left everything he owned to his wife of 11 years, Ms. Karen Baja. But Mr. Donaldson's daughter, the plaintiff, says this wasn't fair. Well, members of the jury, let us be the first to say, we agree. It wasn't fair that Mr. Donaldson cut his only child out of his will. But But the fact is, that was his decision. Now, this situation would be hard for anyone to deal with, and in just a moment, you'll hear all the crazy ideas that the plaintiff has come up with in order to explain her father's disappearance. But no matter the plaintiff's theories or her unwillingness to accept her father's decision, none of that changes the fact that Miss Baja had nothing to do with his disappearance. Good evening. My name is Corey Posey, and I, along with my co-counsel Rachel Maxwell, have the privilege of representing Mr. Donaldson's wife in today's case. Now, the plaintiff wants you to believe that we're here because Karen Baja did something terrible. But the truth is, we are here because the plaintiff cannot accept her father's decision. You see, you will learn that Mr. Donaldson had a pattern of leaving. When he first met Miss Baja, he was still married to the plaintiff's mother. But he fell so hard, so fast for Miss Baja, that he ended up leaving his wife and their child, the plaintiff. This time around, you will learn the police found no evidence of foul play, no evil explanation for Mr. Donaldson's disappearance. He simply fell in love again. In fact, you will learn that Mr. Donaldson had taken a mistress in Costa Rica, and he'd been frequently flying off to see her. And then on August 18th, 2012, he simply flew off to see her again. Only this time, he either decided he wasn't going to return, or he was involved in a plane crash, or he died some other way. We simply don't know what happened to Lou Donaldson. And as such, the plaintiff will not be able to meet their burden in today's case. And let me be clear, the plaintiff holds the entire burden in today's case. They must prove to you 4 things. First, that Lou Donaldson is in fact dead. Second, that his death was caused by Karen Baja. Third, that the plaintiff suffered injuries, damages, or losses as a result of her father's death. And fourth, that Ms. Baja is to blame for that as well. Now, they must prove to you all 4 things. But the plaintiff won't be able to meet their burden today because no one, not the plaintiff, not Ms. Baja, not the police, no one can even say that Lou Donaldson is dead. And certainly no one can say that Ms. Baja had any responsibility in his disappearance. You'll learn that no body was ever found. The police never named Ms. Baja a suspect in her husband's disappearance. And even the insurance company, the people responsible for paying out a whopping $5 million to Ms. Baja, cleared her as having no involvement in her husband's disappearance. Now, you will learn that Lou Donaldson did have a will, and he created that will out of either respect for his 11 years of marriage or the business that he built from the ground up, and maybe even a little bit out of guilt. But the fact is, in that will, he left everything he owned to his wife. Later today, you'll hear from insurance claim investigator Chris Renard. And it's important that you remember Ms. Renard was hired by the insurance company, not by Ms. Baja. She will tell you that she was hired to make sure that paying out that $5 million was appropriate to give to Ms. Baja. And she will tell you that it is important she gets it right the first time around, because if that's paid to the wrong person, her company faces high court costs, and she could even lose her job. Listen carefully. When Ms. Renard tells you she ultimately concluded that $5 million should be paid to Ms. Baja. She had a reason to find something wrong with Lou Donaldson's will or with Ms. Baja, and she simply could not. Now, we're not here today because of Ms. Baja. We are here today because the plaintiff is grasping for anything to make her father's disappearance make sense. We are here today because the plaintiff cannot accept her father's decision. We're here today because the plaintiff feels entitled to her father's wealth and to his business. But members of the jury, the evidence will show Lou Donaldson told us exactly where he wanted his money to go and who he wanted to take control of his business. And that was his wife, the woman he spent nearly every day side by side with at that big cat sanctuary, sharing their passion for these cats. That is, until he realized he had a little more leaving left to do. Now, we wish that that we could give the plaintiff all the answers she needs in order for her to accept her father's disappearance. We stand by her by saying that this was unfair. But the fact of the matter is, this was her father's final decision. Ms. Baja is not responsible for Mr. Donaldson's decision. And the plaintiff cannot ask you to change her father's decision. And once her husband left her, Ms. Baja was left to pick up the pieces. She had a business to continue running, a business rescuing and caring for these sweet exotic cats whom she adored so greatly. Ms. Baja has been dealing with her husband's abandonment for over 8 years now. That is why at the conclusion of today's trial, we will ask that you finally let Karen Baja move on with her life and find her not liable.
Thank you, counsel. We'll now turn to the plaintiff's case in chief. Is the plaintiff ready to call their first witness?
Yes, Your Honor. Plaintiff calls Cam Donaldson.
And Ms. Donaldson, I will remind you that you are constructively sworn in for your testimony today.
Yes, Your Honor.
Will you please introduce yourself to us?
I'm Cam Donaldson.
Cam, tell me what your family was like.
It was always just me, my mom, and my dad, and that's why me and Dad were so close.
What was your dad's name?
He was Lou Donaldson.
What was your dad like?
He was a good man, a self-made man. He didn't have much formal education, but he really worked from the ground up.
What did your dad do for a living?
Well, he started off selling used cars, but big cats were always his true love. Once he saved up enough money, he opened Wild Life.
What is Wild Life?
It's a sanctuary for big cats. We had lions, tigers, leopards, and more.
You say we. Did you ever work there as well?
I did, side by side with him for 20 years.
What was your role there?
Well, I was Dad's right-hand man. I really did it all. Officially, I was his assistant, but he used to joke that I knew more about the business than he did. I ordered supplies, I did Dad's schedules, I wrote the checks, I answered the phones, I ran the books. I did just about everything.
Are you still working at Wild Life?
No, I am not. The defendant had me fired days after Dad allegedly disappeared.
Who is the defendant?
Karen. She's the woman that my father married who I think is responsible for his death.
When did your father die?
Well, Karen had him declared legally dead on August 18th of 2017.
When was the last time you saw your father?
I last saw him on August 17th of 2012 when he was leaving the office, Friday afternoon.
When he was leaving the office, did you have a conversation?
Yes.
Objection calls for hearsay.
Response, counsel?
Your Honor, I am going into a statement that may seem like hearsay. However, it classifies as a statement of intent and an invitation, and that's the only purpose I'm using it for.
The objection is going to be overruled for now.
When he was leaving the office, did you have a conversation with him?
Yes, he invited me to dinner on Sunday.
During that conversation, did your father make any mention of plans to travel out of the country?
No, he did not.
Are you aware that the defendant is claiming your dad flew himself to Costa Rica?
Well, I am aware, but that would have been impossible.
Why is that impossible?
Because they found his van parked at an airstrip with his glasses and his keys inside. Dad was blind as a bat. There's no way he could have flown a plane without his glasses.
Did your dad keep any of his planes at that airstrip?
No, he did not.
Earlier, you mentioned that it was your job to maintain the books at Wild Life. Did you also have access to your father's personal financial records?
Yes, I had records of his ATM statements, his credit card bills, and his financial accounts.
Your Honor, at this time, I'm citing opposing counsel and the witness to page 54 of the record, alternatively Bates 15. I'm marking that as Plaintiff's Exhibit 1. Cam, can you tell me what this is?
Yes,
What is it?
that's my dad's bank statements.
Does this accurately reflect your father's bank statements?
Yes.
Your Honor, at this time, plaintiff offers plaintiff's exhibit 1 into evidence.
Any objection from the defense?
No, Your Honor.
Without objection, plaintiff's number 1 will be admitted.
Your Honor, may I publish this by screen sharing?
Yes.
Looking at your father's bank statements, when was the last time any money was taken out of his account?
Well, we bought animal supplies on August 17th of 2012, and there's been no activity since then.
When did you first find out your father was missing?
August 19th, 2012, when I responded to an attempted break-in at the Wild Wildlife office.
How were you alerted to that break-in?
Around 6 a.m., the alarm at the office went off, and I live nearby, so I drove over. When I got there, I saw that the padlock on the gate had been cut off and that the back gate had been pried open.
Were the police there that night?
The police drove in right behind me.
Who else was there?
The defendant and some guy I did not even recognize was there with her. The guy was carrying a lock cutter and the defendant was carrying a lock box.
Were you familiar with that lockbox?
Yes, that is the lockbox where Dad kept his will, and I kept it locked in the bottom right-hand drawer of my desk.
When you saw the defendant, did she say anything to you?
No, she was just standing there smiling at me.
Did she say anything to anyone?
Yes, she told the police that she was the owner of Wild Wildlife, and if they had any questions for her, they should contact her attorney.
Was anyone aware at this point that your father was missing?
No, at that point, Karen was the only one claiming that my dad was missing.
You told us that the lockbox the defendant carried away contained your father's will. Have you seen that will since?
I have not seen the will that Dad kept in the lockbox, but I have seen another will that the defendant produced after Dad disappeared.
Your Honor, at this time, I'm citing opposing counsel and the witness to page 53 of the record, or Bates 14. I'm marking that as Plaintiff's Exhibit 2. Pam, can you tell me what this is?
Yes,
What is it?
that's the will that the defendant produced after Dad disappeared.
Has this been changed or altered in any way?
Nope.
Your Honor, plaintiff offers Plaintiff's Exhibit 2 into evidence.
Any objection from the defense?
No, Your Honor.
Without objection, plaintiff's 2 will be admitted.
Your Honor, may I publish by screen sharing? Excuse me.
You may.
Looking at this will, how was your father's estate divided?
Karen was left with everything, and my mother and I were left with nothing.
Who was named executor of this will?
This will provided that Karen would become the sole executor should my dad die or disappear.
And what is the date on this will?
It's June 14th, 2012.
How was your father's relationship with the defendant like in the summer of 2012?
Objection. Calls for speculation.
Response, counsel.
Your Honor, this witness has personal knowledge of her own father and stepmother's relationship. Additionally, she worked with both of them at Wild Wildlife.
For now, the objection is overruled.
What was your father's relationship like with the defendant in the summer of 2012?
It was bad.
Had you heard the defendant and your father fighting?
I heard them arguing in my dad's office about 2 weeks before he disappeared.
What was your objection, counsel?
Hearsay, Your Honor.
Response?
Your Honor, I only intend to reference one statement, and I have not gotten there yet, so.
At this time, the court's going to find the objection premature. The question was whether or not an argument was heard. There was not a question about the contents of any argument, so the objection is overruled.
Had you heard your father and the defendant fighting?
I heard them arguing in my dad's office about 2 weeks before he disappeared.
What were they arguing about?
My dad asked for a divorce again.
Objection.
Your objection?
Yes. I'd renew that hearsay objection now, Your Honor.
Response?
Your Honor, this goes to state of mind and intent to divorce under 803.3.
The objection is overruled.
Cam, what were they arguing about?
My dad had asked for a divorce again.
How did the defendant respond?
She was furious and she stormed out of Dad's office.
What did your father do?
He came out of the office and he was visibly shaken. He was upset.
While your father was visibly shaken and upset, did he say anything?
Objection, Your Honor. Calls for hearsay once again.
Your response, counsel.
Your Honor, this is clearly an excited utterance under 803.2. The record specifically states that Mr. Donaldson excitedly uttered and that he was visibly shaken and upset.
Given the foundation provided about the state of mind and demeanor of the declarant at the time, the court will overrule the objection and allow the witness to answer.
Cam, while your father was visibly shaken and upset, did he say anything?
Yes, he said if anything ever happens to me, be sure to have the police look into Karen because she will be the one responsible for my death.
No further questions, Your Honor.
Cross-examination.
Ms. Donaldson, I just have a few questions for you. I'd like to talk about your father first. He was a pilot, right?
Yes.
He owned multiple planes.
Yes, he did. That was his hobby.
He traveled often.
Yes.
You didn't always travel with him, did you?
Not always.
Now, you mentioned on direct that he never kept any planes at the hangar where his van was found.
No.
He bought and sold planes all the time, right?
Yes, he did. It was another money-making business he had. He was so hardworking.
And nobody, including yourself, knew how many planes he had at any given time, right?
Not exactly.
So that's a no, you didn't know how many planes he had at any given time.
No, not at any given time.
And he didn't properly register these planes that he bought and sold, did he?
No, not all the time.
And he didn't always file flight plans when he flew?
No, I always got on to him about that, but no.
And at the time that he disappeared, his pilot's license was suspended, right?
Yeah, it had been.
Now, I'd like to talk to you a bit about your role at the sanctuary. You were your father's assistant, correct?
Yes, I was his right-hand man or lady.
You had been in that role for 20 years, right?
Yes.
You had never been promoted or moved to any other position at Wild Wildlife?
I don't know what there is to be promoted more than the main guy's right-hand man. I love that job.
But that's a no, you never held any other positions.
Nope, I had the best one there.
Now, you had that position before your father even met Miss Baja, correct?
Yes.
And Miss Baja was 20 years younger than your father.
Yes.
And your father was still married to your mother when he met Miss Baja.
I think so.
And he left your mother to be with Miss Baja, correct?
Yes.
Now, shortly after Miss Baja took control of the sanctuary, she fired you from your position, correct?
Yes, she did.
That upset you.
I mean, it was hard.
Now, you believe that the cat should be under your control, not hers, right?
I mean, as long as someone's properly taking care of them. Of course, I've grown up with them. I would love to be the one to take care of them.
But that's a yes, you believe that the cat should be under your control specifically.
Yes.
Now, whenever you, it wouldn't be unfair to characterize your feelings toward Miss Baja as hostile, would it?
I didn't really like her, so I suppose so.
Well, you've threatened, or not threatened, but you've wished violence against her, haven't you?
Yes, we've all said things we don't mean, but I definitely had some hard feelings towards her.
Now, I'd like to talk to you about some of the things that you said on direct as well. You believe that Miss Baja is responsible for your father's disappearance, correct?
I do.
You're aware that she's never been taken into custody in connection with his disappearance.
Yes, I am aware of that.
Now, you're also aware that no body was ever found in this case?
Yes, unfortunately.
Now, on direct, you also mentioned a morning shortly after your father disappeared at Wild Wildlife.
Yes.
When the alarms went off.
Yes.
Now, you said that you arrived and you saw Miss Baja there.
I did.
And whenever you saw her, she didn't have any injuries to her person, did she?
Not that I noticed.
And You said that police arrived shortly after you, correct?
Yes, they drove in right behind me.
And they didn't take Miss Baja into custody at that time.
No, not at that time.
Now, you don't have a police report from that night to show the jury, do you?
Not that I brought to court with me.
Now, I'd like to talk to you about your father's last will and testament. You said that his original last will and testament was in the lockbox that Miss Baja supposedly took that morning.
Yes.
But we don't have a copy of that will here today, do we?
No, we don't, because Miss Baja left Wild Wild Life with it. This is the last time I saw it.
And there are no witnesses to that will testifying today either, are there?
Nope.
Now, the first time that you saw his current last will and testament was a few weeks after that morning, correct?
Yes.
And you had already been fired at that point, correct?
Yes.
And the will wasn't in effect when you were fired.
Don't believe so.
It wouldn't be in effect for another 5 years, right?
Yes.
So Ms. Baja had the authority to fire you before there was any transfer of property through that will.
I don't know about authority. I just know she told me I didn't have a job anymore and I wasn't going to argue with her about it.
So you never argued with her about it then?
I mean, she told me to get out and I just left.
And you never tried to resume that position?
No.
Now, you didn't hire anybody in 2012 to look into your father's disappearance, did you?
No, because I knew that the police department was handling it. I fully trusted them with the investigation.
You also didn't hire anybody in 2013 either, did you?
Because the police department was handling the investigation and I trust my local police department.
And after 3 years went by, you didn't hire anybody?
No, because after 3 years, I still trusted my local police department.
But you did hire somebody in July of 2017.
Yes.
And that was right before your father's will would be executed?
Yes.
And right before his life insurance policy would be paid out?
Yes.
Thank you, Ms. Donaldson. No further questions?
Any redirect by the plaintiff?
Yes, Your Honor.
You may proceed.
Cam, why did you say you hate the defendant?
Because I believe she killed my father.
What were your duties at Wild Wild Life?
I did it all. Dad used to say that I knew more about the business than he did.
Did your father tell you that he was going to Costa Rica the weekend he disappeared?
No, not once. And he would always tell me when he was leaving.
Why did you not tell the police that you believed your father disappeared?
Because I trusted that the police would handle it.
Who works at the police department?
Karen's big brother.
Is this case still active?
It is.
No further questions, Your Honor.
May this witness be excused?
Yes, Your Honor.
Any further witnesses for the plaintiff?
Yes, Your Honor. At this time, plaintiff offers Plaintiff's Exhibit 3 into evidence. We seek to introduce a video that will feature an unavailable witness.
And can you provide is there a bait stamp associated with that exhibit?
I do not believe there is a bait stamp. However, we seek to introduce the video. However, there is a transcript of the video that is found in the record on page 30. And we only seek to introduce the 4th and 5th paragraphs.
Is there any objection from the defense to introduction of plaintiff's 3?
Yes, Your Honor. This is hearsay within hearsay. And while the second layer of hearsay may be party opponent's statement, there is no exception that applies to the first layer of hearsay.
And what is that first layer of hearsay that you are referring to, counsel?
That is Bob Exotic speaking. I believe that's what opposing counsel is attempting to introduce. Bob Exotic is talking, and while he is an unavailable witness, this testimony doesn't fall under any of the exceptions that are applicable to unavailable witnesses.
Response from the plaintiff?
Yes, Your Honor. It is stipulation number 4 on page 9 of the record that Exotic Bob is unavailable pursuant to Rule 804A. Furthermore, Bob Exotic's statements are statements against interest that any reasonable person in his position would only make statements about an illegal deal that could subject him to additional criminal prosecution if those statements were true. And additionally, the threat that I'm referring to as well contains a party opponent admission, which would classify under 801D2. Therefore, any double hearsay would be overcome by these exceptions.
At this time, the court, pursuant to stipulation number 4 and the understanding that Exotic Bob is an unavailable witness pursuant to 804A, and the understanding that pursuant to Federal Rule of Evidence 804B, the primary statements made by Exotic Bob in the video are admissions against interest. The court is going to overrule the hearsay objection as to both layers and allow Plaintiff's Exhibit 3 to be admitted into evidence at this time.
Your Honor, may I be heard briefly to clarify?
Briefly, counsel.
Would that just be that 4th paragraph that does include statement against interest? Nothing further?
The court's going to find that the entirety of the video may be admitted.
Yes, Your Honor, thank you.
You may publish, counsel.
Thank you, Your Honor.
You see, it was 2 years, 2 weeks, and 2 days to the day that her husband was last seen alive. She and I was working on a highly illegal deal. It was illegal importing leopards and lions. Leopards was for her, leopards was for me. Lions was for her. Now, we never worked together before, and we never worked together since. But due to the severe illegality of the deal, we thought it best to work together, so we did. And at the end of that meeting, Karen Vaja walked out of my office. She stopped, and turned around, and she came marching back to my desk, and she leaned over, and she looked me right in the eye, and she said, "Exotic Bob?" That's me, Exotic Bob. She said, "Exotic Bob, I swear if you double-cross me on this deal, I will do to you exactly as I did to my husband." She said, "There won't be no disappearance, no mythical flight to Costa Rica." She goes, "Your last supper will be you. I'll feed you to my kitties just like I did him." And then she turned around and she walked out of my office. That's all I've got to say about that.
Further exhibits or witnesses for the plaintiff?
Yes, Your Honor. Plaintiff calls Taylor Pride.
Mr. Pride, I'll remind you that you are under oath. You may proceed, counsel.
Yes, Your Honor. May I have a moment to gather my notes real quick?
Certainly.
Could you please introduce yourself?
My name is Taylor Pride.
How are you involved in this case, Mr. Pride?
I was hired by Cam Donaldson to analyze her father's Lou's alleged signature on the will presented by the defendant.
Now, before we get into your analysis of that will, let's talk about your background. What do you do for a living?
I work at a private investigator at the firm I started, Private Investigations.
Tell us how you became a private investigator.
So I started my career with the Pioneer Police Department in 1998 as patrol officer, but was quickly promoted to detective in 2000. I left the police department in 2016 and started Private Investigations.
What kind of cases have you investigated?
I've investigated every type of case, from economic crime to murder.
Now, before we get into your investigation and your opinion, let's talk a little bit more about your background. Have you ever investigated forgeries?
Yes, while I was assigned to the economic crime units at PPD, I spent a lot of time investigating forgeries.
Have you received any education in analyzing signatures?
Yes, I attended an extensive 2-week seminar for the American Association of Handwriting Analysts in which I was trained to analyze and compare handwriting.
And what is the American Association of Handwriting Analysts?
It's just the premier organization when it comes to graphology and document examination.
Does your current job as an investigator ever involve any kind of handwriting analysis?
Oh yes, I continue to practice in the field.
Are you certified in handwriting analysis?
Yes, I have testified as a handwriting analysis expert 15 times since 2002 in civil cases for both the plaintiff and the defense, as well as in criminal cases.
Well, are you certified in handwriting analysis?
Yes.
Okay, good deal. Your Honor, at this time, we tender Mr. Pride as an expert in forensic document examination.
And it's my understanding that that is meant to encompass handwriting analysis as well.
Yes, Your Honor.
Okay. Any voir dire from the defense?
No, Your Honor.
Okay. Is there any objection from the defense to the tender of this witness?
No, Your Honor.
Seeing no objection, the court will find that Mr. Pride shall be qualified as an expert in the field of, was it forensic document analysis? That meant to include handwriting analysis as well.
Yes, Your Honor.
Court will so find. You may proceed, counsel.
Mr. Pride, have you reached an opinion as to whether the will produced by the defendant is a forgery?
Yes, I have.
Now, before you tell us what that opinion is, will you tell us what you reviewed in coming to your opinion?
I reviewed all the documents Chris Renard, the insurance investigator, reviewed. The signature on what the defendants claimed to be Mr. Donaldson's last will and testament, and Mr. Donaldson's signature on his driver's license, a petition for a restraining order, and a note he wrote to his daughter in May of 2012.
On your objection, counsel.
I'm sorry, a violation of the motion in limine temporary restraining order, which is mentioned.
At this time, the court is going to move to strike the witness's statement regarding the temporary protection order and will admonish the jury that it shall disregard any statements it may have heard regarding a temporary protection order in this case.
Your Honor, if I may suggest, because I know that this witness relied on that signature, we could simply call it a court document if that's okay with opposing counsel.
As to that request, counsel.
Yes, Your Honor, that's fine with us.
All right, it'll be acknowledged as a court document.
Now, are these documents and signatures the same types of things that other handwriting analysts in your field would rely on in forming an opinion?
Yes.
Is your opinion based on sufficient facts and data?
Yes.
Is your opinion to a reasonable degree of professional certainty?
Yes.
Let's talk about your analysis of the signature on the will. What are the steps that are involved in analyzing and comparing handwritings?
Well, there are 3 steps involved. First, obtain a known sample from the author. Second, analyze that known sample. And third, compare the known samples to the handwriting in question.
Is that what you did in this case?
Yes, that's correct.
Let's take that first step in your analysis. What were the known samples of Mr. Donaldson's handwriting that you obtained?
Those would be the signatures on his driver's license, a court document, and the note he wrote to his daughter that I previously mentioned.
Citing opposing counsel to page 40 of the record, alternatively known as Bates 7, and citing the court also. Mr. Pride, please look at page 40 of the record, which
Yes.
I'm now marking as Exhibit 4. Do you recognize Exhibit 4?
I do.
What is Exhibit 4?
Exhibit 4 is the document prepared by Chris Renard from Summit Life Insurance.
Has this document been changed or altered in any way?
No.
Your Honor, plaintiff offers Plaintiff's Exhibit 4 into evidence, constructively redacting all but the signature comparison chart.
Any objection from the defense?
So long as it's redacted, no, Your Honor.
Understanding the stipulation to redact all portions except for the signature lines, was this marked as Plaintiff's Exhibit 4?
Yes, Your Honor.
Plaintiff's 4 will be admitted.
May I publish my screen to?
Does the publication retain the redactions? Or
Yes.
those? Okay,
Now, Mr. Pride, you said that the second step is to analyze the known samples. What are handwriting analysts looking for when analyzing and comparing when analyzing known samples?
An analyst looks for handwriting characteristics such as shapes, curves, angles, stroke directions, legibility, letter height and weight, capitalization, and embellishment.
Does an analyst focus only on individual letters?
No. A good analyst will look at not only the individual letters, but focus on how certain letters connect and identify connection patterns.
Now, you told us the third step was to compare the known signatures to the signature in question. Did you do that in this case?
Yes.
Were there differences between Mr. Donaldson's known signatures and the signature on the purported will that was produced by the defendant?
Yes.
Were there any differences in the individual letters?
Yes.
Why don't you tell us what those differences were?
Well, first, the D in Donaldson on the known sample is a single movement in which the pen is lifted off the paper just for a split second.
Can you indicate that on Plaintiff's Exhibit 4?
Yes. So you'll see it's just lifted off for a second there, right as it comes around.
Now, is that the same on the will?
No, the D in the Donaldson on the will is clearly two distinctive pen strokes.
What was the next difference?
Well, the next difference was the writer of the signature on the will writes every letter, including the lazy second O in Donaldson individually.
Now, is that lazy second O written out in Mr. Donaldson's known signatures?
No, the lazy O is not clearly written out on Mr. Donaldson's known signatures.
Were there other differences you noted?
Yes. In fact, the biggest mistake I noticed was that the writer of the signature on the will produced by the defendant was was lifting the pen more frequently than Mr. Donaldson did.
Are there any other factors a forensic document examiner is looking for when comparing known samples to the handwriting in question?
Analysts are looking for retouching, hesitation, or other signs of unnatural writing.
Were there other circumstances surrounding the will that you considered in forming your opinion?
Yes, I also considered the language of the will.
What language did you consider?
The will provided that the defendant would be the sole executor of his estate should he die or disappear.
Have you ever seen that kind of die or disappear language in other wills?
As someone who's investigated hundreds of forged wills, I have never seen the term disappear in a will before. In my experience, people don't plan a will in case they possibly disappear.
Now, Mr. Pride, what is your opinion as to whether the will produced by the defendant is a forgery?
It is my opinion that the signature on the will was not written by Mr. Donaldson. It is a forgery.
No further questions, Your Honor.
Thank you, counsel. Cross-examination.
Yes, Your Honor. Now, I'd like to talk a little bit more about that will, Mr. Pride. You said that the first step in reviewing that will was to obtain known signatures.
Yes.
And the best thing to do is to find signatures that are original.
Yes.
Best to avoid things that are photocopied.
Right.
And in reviewing Mr. Donaldson's will, you used his signature from his driver's license and a signature from a court document.
Correct.
So you did, in fact, use copies of his signature.
I used what was available to me at the time. So yeah.
So you agree those were copies of his signature. They were not original copies.
I believe they were sent to me digitally. I did not review a original copy.
So you don't have anything that Mr. Donaldson actually put the pen to the paper on?
No.
And actually, you had a third sample, and that was the letter that Mr. Donaldson had written to his daughter.
Yes.
He wrote that letter in May of 2012.
Yes.
But you didn't ultimately use that letter.
No.
And that was pretty recent to Mr. Donaldson disappearing.
Yes.
In fact, the jury doesn't have that letter today or that signature to see.
No.
Now, I'd like to talk about the way that you determined that those two known signatures, the driver's license and the court document, were similar.
Yes.
There's a couple here, so just give me a minute to get into these. First of all, you believe that signatures, if they're 100% the same, they're probably forged.
I'm sorry, could you repeat the question?
Sure. If you see two signatures and they are 100% the same, those signatures are probably forged, or at least one of them would be.
Potentially, signatures can be pretty similar. They're generally never alike.
Right. Signatures typically have differences each time someone signs.
Small differences.
Okay. Now, those two signatures, let's get into those. You did determine that those two signatures were in fact a match, the two known ones.
They were very close compared to the third.
And a few of those reasons was because first, the top loop in L is smaller than the bottom loop in Lou Donaldson.
Yes.
And then you mentioned that the O in Lou has an extra loop.
Yes.
And you mentioned that the U in Lou has a small tail embellishment.
Yes.
And that the N at the end of Donaldson has also a small tail embellishment.
Yes.
Your Honor, permission to retrieve Plaintiff's Exhibit 2 and publish.
Granted.
Just 1 second, Your Honor, I apologize. Okay, Mr. Pride, if you'll just let me know that you see that signature on your screen.
Yes, I do.
Okay, and now going from that criteria that you found similar in those two known signatures, you'd agree here that the top loop of L is smaller than the bottom loop,
Yes.
that there are extra loops in the O of Lou,
Yes.
that the U has a small tail embellishment,
Yes.
and that the N at the end of Donaldson has a small tail embellishment.
Yes.
You also mentioned that the capital D had two separate pen strokes in all three signatures.
The capital D, what I mentioned was that it slightly lifts off the page.
Okay. Now, you also believe that the language die or disappear was strange.
Yes.
And when you concluded your investigation, you found no physical evidence that Mr. Donaldson had actually died.
No.
No murder weapon.
No.
No blood.
No.
So at the very least, you as well as the police could agree that he did in fact disappear.
Yes.
Now, I'd like to talk about a bank statement. You reviewed Mr. Donaldson's bank statement in preparation of your investigation.
Yes.
Okay, permission to retrieve Plaintiff's Exhibit 1 and publish.
Granted.
Okay, Mr. Pride, if you'll just let me know when you see that on your screen.
I can confirm. I see it now.
Okay, thank you. Now, when Mr. Donaldson signed that will, that was dated on June 14th of 2012.
Yes.
And when you pulled this financial statement, it begins on August 1st of 2012.
Yes, that's the statement date.
And this is the only financial record that's provided to the jury today.
Yes.
So we have no way of knowing whether or not cash was withdrawn before August 2nd of 2012.
Correct.
It's possible that Mr. Donaldson maybe has an offshore account.
Yes, I am not aware of it. We did not find any in our investigations. This was his only known bank account, but yes, it is possible.
And it's possible that maybe he withdrew that money and stored it in an account that didn't belong to him.
Again, it's possible. I can't speak definitively upon it.
Now, Mr. Pride, at the conclusion of your investigation, it's possible that Mr. Donaldson is sitting somewhere in Costa Rica today.
It's anything's possible. I've heard Elvis is in Cuba.
But that's a yes, it's possible that Mr. Donaldson's in Costa Rica.
Again, it's possible. It's not definitive, so I don't want to give a yes or a no.
Well, it's also possible that his plane could have crashed on his way down there.
That's same possible. No way to know yes or no.
Thank you, Mr. Pride. No further questions, Your Honor.
Thank you, counsel. Is there any redirect by the plaintiff?
Yes, Your Honor. Now, Mr. Pride, you were asked about your investigation into Mr. Donaldson's disappearance. Did you investigate whether it was possible that Mr. Donaldson flew to Costa Rica the weekend he disappeared?
Yes.
Were you able to determine if Mr. Donaldson was actually in Costa Rica after August 17th, 2012?
We found no evidence that Mr. Lou Donaldson was in Costa Rica after August of 2012.
You were also, there's mention of an offshore bank account on Cross. How do you know that Mr. Donaldson only had one bank account?
That would be based upon my review of Chris Renard's report.
And how much was in Mr. Donaldson's only bank account?
$100,000.
No further questions, Your Honor. May the witness be excused.
This witness may be excused. All right, we've concluded the second witness for the plaintiff. Does the plaintiff have any further witnesses to present?
Yes, Your Honor. The plaintiff calls Carl Bannister by deposition. Stipulation 4 on page 9 of the record provides that Mr. Bannister is unavailable pursuant to Rule 804A. For the court and counsel's convenience, if no objection, plaintiff will read the entirety of page 33, which is the first page of the deposition, continuing to the third question and answer on page 34 of the deposition, which is the second page of the deposition. And then on the third page of the deposition, otherwise known as page 35, beginning with the second question on that page until the question reading, no further questions.
Is there any objection from the defense?
No, Your Honor, so long as the defense be able to bring up some of the questions that opposing counsel doesn't cover in their examination of him afterwards.
That'll be fine. You could also do so in your case in chief, but we'll allow it after. It seems like a convenient time. Go ahead, counsel.
Your Honor, may I read the questions while Ms. Sims reads the answers?
That's fine.
And would Your Honor like for me to explain to the jury what a deposition is, or would the court prefer to do that?
We can provide an instruction to the jury to go back to the deliberation room. No need, counsel.
Yes, Your Honor. Okay. Hello, Deputy Bannister. Would you please state your name and spell it for the record?
Deputy Carl Bannister, CarlBannister.
What do you do for a living?
I'm a deputy sheriff for Pioneer County, Statesville.
How long have you worked as a deputy sheriff?
I was first hired out of the academy in May of 2005 by Pioneer County. I've worked there for over 15 years now.
How are you involved in this case?
Well, I'm not involved in the case, but I guess you could say I'm here because my sister is Karen Baja.
Are you older or younger than your sister?
She's my little sister, as I'm older by a couple of years.
Do you have a close relationship with your sister?
We're family, so there are ups and downs to any family relationship. However, I would say that we are pretty close.
Okay. Let me ask you about the night, early morning hours of August 18th, 2012. Do you remember that pre-dawn time?
Yes, I do.
How do you remember it?
I was on duty that night, graveyard shift, so from 12 a.m. to 8 a.m.
What do you remember about that time?
Well, it was normal sort of shift. I was just answering patrol calls when I got a personal call from Karen.
When was that?
It was close to 3 a.m. She had gone out to the grocery store late at night in order to get some milk or something for some newborn tiger cubs. She had car trouble and needed a ride home as soon as possible to get back to the cubs.
Did you go to pick her up?
Yes, I did.
Did you use your patrol car?
Yes, she was actually in my patrol area.
When did you pick her up?
Well, I was just finishing the paperwork on a DUI arrest, so it took me just a few minutes. I wrapped up what I was doing and met up with her around 3:20 a.m. or so.
Are you aware that the Pioneer Sheriff's County Office keeps tracking records for all vehicles?
Sure. It is a good way to know where each deputy is located in the jurisdiction during a shift.
Are you also aware that there is no record of your patrol vehicle moving from 3:20 a.m. until nearly 6:30 a.m. as it was showing it was near the grocery store close to Miss Baja's home during that time?
Yeah, I looked back at that in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue was noted in a maintenance log and it was replaced the next day.
Let me turn your attention to approximately 1 week later, August 24th, 2012. Did you see your sister, Miss Baja, that day?
Yes, I drove her to a small airport so that she could pick up Lou's van. It was about 40 miles away, and I didn't want her to have to pay for a ride, so I took her. The sheriff's office released his van to her right away. It is my understanding that they didn't need to examine it or anything. So she grabbed it and we caravaned back to Pioneer.
No further questions.
And defense counsel, if you'd like, now would be a good time for you to read in your portions.
Yes, Your Honor. And I'll just use my co-counsel for that. And I direct her to page 2 of the deposition. About halfway down the page. When did you pick her up?
Well, I was just finishing the paperwork on a DUI arrest, so it took me just a few minutes. I wrapped up what I was doing and met up with her around 3:20 a.m. or so.
So you were very close to her location.
Yeah, I guess.
Where did you meet with her?
Her car was on the side of the road a couple blocks away from the grocery store.
How close was this to her home?
A couple of miles at most.
Was she going to or coming back from the grocery store?
I believe she was coming back as she had some groceries with her.
How was she doing whenever you met up with her?
She was fine. She was just really concerned about those newborn cubs and wanted to get back to them as soon as possible.
Did you drive her back home?
Well, I first took a look at her car and it would not start. So I made sure it was safe by the side of the road and then took her home. We got to her house around 3:45 a.m., definitely before 4 a.m.
Do you know if Lou Donaldson was home that night?
No, we didn't talk about him. She was just focused on those tiger cubs and kept talking about them, how cute they were, how they were doing, stuff like that. She just loves animals, especially big cats.
Did you go into the home at all that night?
No, I was on duty and had to get back to work. I dropped her off, wished her luck with the cubs, and headed off.
Now I'd like you to direct you to the bottom of that page under the examination by Mr. Keyes section. Deputy Bannister, how was your relationship with Mr. Donaldson?
It was fine. He did some great things for my sister, helping her find her passion for animals, big cats in particular, but he could be difficult.
What do you mean by that?
Well, he was moody at times and suspicious of people. He seemed paranoid. He would go off to Central America for extended periods of time and not want to talk about what he was doing down there.
Thank you. No further questions.
All right. Any further witnesses for the plaintiff at this time?
No, Your Honor. The plaintiff rests.
All right, that brings us to the midpoint of our trial at this point. Before moving to defense's case in chief, are there any motions on behalf of the defense?
Yes, Your Honor, the defense moves for a judgment as matter of law pursuant to Federal Rules of Civil Procedure 50. In this case, the plaintiff side had to prove that Mr. Donaldson is dead and this was because of Ms. Baja and the plaintiff's damages and that this was also caused by Ms. Baja. A reasonable jury could not find after the case that the plaintiff just put on, especially to the first element that Mr. Donaldson is in fact dead. And because they can't prove that, they cannot prove any of the other elements as those hinge on the first element.
Response from the plaintiff.
Yes, Your Honor. As Your Honor knows, when considering the defendant's motion, the evidence and all inferences from that evidence must be viewed in the light most favorable to the non-moving party, which is the plaintiff in this case. Your Honor, we have presented evidence that Lou Donaldson has been declared legally dead, that after Mr. Donaldson told his only child to investigate the defendant if anything ever happened to him, he disappeared, that his last will and testament was clearly a forgery, and that after he disappeared, no funds were withdrawn from his bank account. Your Honor, we have proved that the defendant had a clear motive. And as Your Honor knows, the law makes no distinction between the effect of direct and circumstantial evidence. And there is more than sufficient evidence and inferences from that evidence for the plaintiff's claim to be presented to a jury.
All right, both counsel have properly outlined the standard that the court needs to follow when determining whether or not what we'll call a halftime motion should be granted. This court finds that when the evidence viewed in the light most favorable to the plaintiff or the non-moving party, a reasonable juror could find that enough evidence has been presented to find that the plaintiff has met their burden in this case, specifically in regards to the first instance that Mr. Donaldson is indeed deceased. There was evidence that the court heard about the deceased being declared legally dead by some other judicial body at some point in the past. That evidence, in the light most favorable to the plaintiff, does warrant the case going to the jury. So we will proceed with the defense's case in chief. Do the defense have any witnesses they wish to call?
Yes, Your Honor. May we take a brief 3-minute recess before we do so?
That's a good idea. Why don't we take about a 5-minute recess? I know the time is 5:20 p.m. at this time. We'll return at 5:25 p.m.
Yes,
Thank you, Your Honor.
All right, and counsel, as you come back into the Zoom chat, if you could just turn on your video to make sure that we have all counsel present.
I'm sorry about that, Your Honor.
Oh, you're fine. Is your co-counsel back?
Yes, Your Honor, I believe she is back. Or I think that she may have run to the restroom, but she'll be back in a second.
That's totally fine.
May we take like an additional, like maybe 2 minutes to run and get her real quick?
That's totally fine. Yep, we're moving at a good pace right now, so we can take a couple more minutes.
Yes,
Just
Your
turn
Honor.
your videos on when you get back, okay?
Yes, Your Honor, will do.
All right, at this time, the court will recall case number 082263, Cam Donaldson versus Karen Baja. The court will note that all counsel are present. We recently, before our recess, had concluded the plaintiff's case in chief. The plaintiff has rested, and the halftime motion raised by the defense was denied. We will now proceed with defense counsel's case in chief. Does the defense have any witnesses they wish to present?
Yes, Your Honor. The defense calls Chris Renard to the stand.
All right, you may proceed, counsel.
Good evening. Can you please introduce yourself to the court?
Yes, my name is Chris Renard.
And Ms. Renard, what do you do for a living?
I am an insurance claim investigator as well as a forensic document examiner.
And who are you employed by?
I'm employed by Summit Life Insurance Company.
Okay, I'd like to talk about your two different roles. First, can you tell us what you do as an insurance claim investigator?
Yes, my job is to investigate claims. So when someone is filing a claim with my company, I conduct a risk survey to assess the loss and how much would need to be paid out. I also collect evidence and documents and just review the claim.
And how long have you been in that role?
I've been doing this for 20 years.
And as far as your role as a forensic document examiner, what does that entail?
Yes, I specialize in handwriting and signature identification. So I look at potentially fabricated documents or altered records and determine if they are in fact authentic.
How long have you been in that role?
I've been doing this for 23 years.
Can you tell us what education you've obtained in order to get those two positions?
Yes, I have a Bachelor of Arts in Criminology, and I've also gone through the Statesville Police Department.
And do you hold any certifications?
Yes, I've been certified by the Board of Forensic Document Examiners and the Association of Certified Fraud Specialists.
And do you attend any trainings in order to stay updated on your qualifications?
Yes, there's annual training and workshops and continued education that I do every year.
Ms. Renard, have you ever testified in court in either of these areas?
Yes, I have. I've testified about 25 times in the field of document examination and 24 times on behalf of Summit Life Insurance Company.
Thank you, Ms. Renard. Your Honor, at this time, the defense moves to tender this witness as an expert in insurance claim investigation, as well as forensic document examination.
Just one moment, counsel. Insurance claim investigation, and what was the second one? Forensic document analysis?
Yes, forensic document examination, Your Honor.
Any voir dire from the plaintiff?
No, Your Honor.
Any objection to this witness being tendered?
No, Your Honor.
At this time, the court will then tender Ms. Renard as an expert in the fields of insurance claim investigations and forensic document examinations. You may proceed, counsel.
Now, Ms. Renard, are you familiar with a policy for a Lou Donaldson?
Yes, Lou Donaldson had a life insurance policy with us.
What was your role in that claim?
Yes, well, Karen Basha filed the claim to collect on the life insurance policy, and so it was my job to investigate that claim and decide whether or not to pay out.
Why does your company ask you to do this?
Well, it's really important that we make sure that we're paying out to the right people to avoid potential lawsuits in the future. So we want to make sure that when we pay out, we get it right the first time.
And what types of situations would cause you to not pay out to a beneficiary?
Yes, we wouldn't want to pay out to someone even if they were the beneficiary if we found out that they were somehow involved in that person's death.
So in this case, did you investigate both Mr. Donaldson's will and his wife?
Yes, I did.
Okay, I want to first talk about Ms. Baja and your investigation into her. How did you begin that investigation?
Yes, so I looked at the facts surrounding the disappearance, and I talked to several witnesses and looked at several documents.
And ultimately, did you ever find that Ms. Baja was charged or even considered a suspect in her husband's disappearance?
No, she was not.
Now, I'd like to talk about the will that you reviewed for Mr. Donaldson. How did you begin your analysis of that?
Yes, well, the first step is always to collect known signatures.
And what known signatures did you collect here?
I looked at the signature that we had for Lou Donaldson on file from the insurance policy that he has with us. And I also obtained a signature from the DMV that he signed when he got his license.
And what about those two signatures? Were they similar?
Yes, they were sufficiently similar.
Did they have any differences?
Yes, there are some minor differences between anyone's signature.
And then what was your next step after obtaining those known signatures?
After I got the known signatures and analyzed those, I also looked at the purported forgery on the will and analyzed that signature as well.
And did you document this comparison in a report?
Yes, I did.
Would you recognize that report today?
I would.
Your Honor, at this time, permission to retrieve what plaintiff has already entered as Exhibit 4 and publish.
You may.
Okay, Ms. Renard, if you'll just let me know when those are on your screen.
Yes, I can see those.
Okay. Can you tell us what each of these three signatures are?
Yes, that top one is the one from the life insurance paperwork. The one in the middle is from the driver's license, and then the one on the bottom is the one on the will.
Now, you said that these first two signatures were a match, but they had some differences. Did you have any reason to believe that those two signatures were not genuine?
No, those are both genuine and the signature of Lou Donaldson.
And when comparing those two signatures to his third signature, what was your ultimate conclusion?
I believe that the signature on the will is genuine.
Did you believe that that signature had differences as well?
Yes, all three of them have some differences.
Can you explain to the jury why someone might sign their signature differently?
Yes, minor differences can come from any number of things. One main one is aging. So we know that the life insurance policy and the signature from the driver's license are older than the signature on the will. It can also come from any changes in health, which can cause potential shaking or other things like that. There's also differences that come from just the care that someone takes when signing it. Sometimes they're more careful and they go slower, and sometimes they're rushed and go faster. There can also be differences based on the surface they're signing on or the utensil they're using, such as a pen or a pencil or a hard surface or a soft surface.
Thank you, Ms. Renard. That sounds like a lot of differences. So ultimately, did you conclude that Mr. Donaldson's signature was genuine?
Yes, that was my ultimate conclusion.
Now, Ms. Renard, let me ask you, if Ms. Baja was considered to not be the person to pay this to, would your company be off the hook for paying out that $5 million?
No, we would still have to pay out the life insurance, but it would just change who it went to. So if Ms. Baja was involved In Mr. Donaldson's death, instead of paying her, we would go to the next of kin or look to see if there were any other beneficiaries listed.
And what might happen if you happen to get your job wrong?
Well, it would put the company at risk for an expensive lawsuit.
Now, Ms. Renard, can you tell us who paid you to complete this investigation?
Yes, I was hired by Summit Life Insurance Company.
In any way, did Ms. Baja or anyone related to her pay you for this investigation?
No, like I said, I was just doing my job for the insurance company. I don't know either of the parties in this case.
And now, when you had to report back to your supervisors at Summit Life Insurance, what was your ultimate conclusion that you delivered to them about that $5 million?
I concluded that Ms. Baja was not in any way involved in the disappearance and that we should in fact pay out the policy to her.
Thank you, Ms. Renard. No further questions at this time, Your Honor.
All right, thank you, counsel. Is there any cross-examination from the plaintiff?
Yes, Your Honor. Ms. Renard, the defendant had Mr. Donaldson declared legally dead on August 18th, 2017.
Yes.
The defendant filed her claim with Summit Life Insurance the very same day.
Yes, a lot of times after they have to wait that 5-year period, once they do get that, they go ahead and file their claim.
Okay. And you were assigned to investigate her claim.
Yes, I was.
But during your investigation, you contacted the sheriff's office.
Yes, I did, because I knew that they were involved in looking for Mr. Donaldson as well.
Right. But the sheriff's office would not show you any evidence.
No, because it was still an active investigation.
Exactly. They actually refused to show you any evidence.
Yes, that's true.
And just like you said, because this investigation is still active, correct?
Yes, although to the best of my knowledge, they have not chosen to arrest Miss Baja as being involved in any way.
Ms. Renard, it's still active.
Yes, it is still active.
Let's talk about the signatures you examined. You reviewed 2 known signatures of Mr. Donaldson.
Yes, I did.
One of those signatures was from his insurance policy.
Correct.
The other was from his driver's license.
Correct.
And you compared those signatures with the signature on the will.
Yes, I did.
Your Honor, may I screen share to Plaintiff's Exhibit 4?
Okay, my apologies, I was muted.
Ms. Renard, can you see Plaintiff's Exhibit 4?
Yes, I can.
All right, down here at the bottom where it reads question signature, this is the signature for Mr. Donaldson's alleged will, correct?
Yes, yes, it is.
And you are aware the defendant is claiming that this question signature is Lou Donaldson's.
Yes.
Now, Ms. Renard, after you compared this question signature with the 2 signatures we know are Mr. Donaldson's, so you did this comparison chart, you were not able to determine if the question signature was actually Mr. Donaldson's.
I believe it to be genuine.
Are you saying that you believe it to be genuine after you compared the signatures?
Yes.
Well, you're aware that you did write a report, didn't you?
I did.
And you wouldn't lie in that report.
No, I believe in
You also wouldn't lie on the stand, correct? You're telling the truth.
In the report, I believe I said that some differences may have been inconclusive, but that the signature itself seems genuine.
Okay. All right. I want to go ahead and cite opposing counsel in the court to Bates 7, which is the signature comparison chart, but the unredacted version. Now, Ms. Renard, could you please flip to Bates 7?
If I may have just a moment.
Your Honor, in the interest of saving time, I'm going to go ahead and object that this is an improper impeachment. May I be heard at a constructive sidebar?
You may.
So this witness has both written a report and then later wrote a statement. And in that statement, she's saying exactly what she's saying on the stand right now. I believe that opposing counsel is trying to backdoor some type of opposing statement to say that she's lying right now, but she is not if you would look at her actual statement.
Well, let's let, at this time, let's let opposing counsel lay the proper foundation and renew your objection at that time. However, impeachment can be done with any written report or any written notes if it's previously been documented. So the objection is going to be overruled at this time pending further foundation.
Yes, Your Honor.
Okay, so you remember doing the signature comparison chart,
Yes, I do.
and you remember writing notes at the end of the signature comparison chart.
Correct.
And in those notes, you claimed that there were sufficient similarities,
Correct.
but also differences.
Correct. All signatures have some variation unless they've been traced.
Right. And right now you are claiming that even after the signature comparison, you believed that the signature was genuine.
Correct. That my ultimate conclusion was that it seemed genuine. It was inconclusive as to whether it was not genuine.
Ms. Renard, I'm not talking about your ultimate conclusion. I'm talking about the notes, and I'm talking about specifically right after the signature comparison. You said that your results were inconclusive, didn't you?
Correct.
And you even said that you cannot say that the signature on the will is either genuine or non-genuine.
Those were from my initial notes when I did this comparison. Yes.
Right, Ms. Renard, and that's what I'm talking about is from your initial notes when you did this comparison. Now, Ms. Renard, your opinion changed because you talked to the defendant?
No.
So your opinion, your ultimate opinion did not change because you talked to the defendant.
Are you referring to my opinion based on the signature analysis?
Yes, I'm referring to your ultimate opinion.
No, I did not change my opinion after speaking with the defendant.
Your Honor, may I be heard outside the presence of the jury?
In regards to what, counsel?
Impeachment. Is it proper? Have I laid the proper foundation is what I'm wondering. Just to go ahead and clarify.
Counsel, you can move to impeach with any statement if you follow proper impeachment procedure. It'll be up to opposing counsel to raise any objections to your foundation.
Yes, Your Honor. Okay, I'd like to cite opposing counsel in the court to Bates 7. At the bottom, it says that she cannot say whether the signature on the will is either genuine or non-genuine. And it's possible that someone tried to copy Mr. Renard or Mr. Donaldson's signature. Now, I'd like to cite the court also to page 38 of the report.
May I ask for clarification? I don't have page numbers. Is that the report that Ms. Renard completed to her company?
Yes, that's the last page. Now, let's look at this report. In this report, you said, following your signature analysis, I spoke in person. You say, thus, I cannot say the signature on the will is non-genuine. It appears to be genuine. There are multiple reasons why they may change. Also, you say that after your signature analysis, following my analysis of the signature, you talked to a person named Miss Lane.
Objection, Your Honor. This is where we renew that motion in limine.
May I respond, Your Honor?
You may.
Under 705, I'm permitted to cross-examine an expert on anything they relied on or even considered or did not consider informing their opinion. The report clearly says that she spoke in person with Miss Lane, then she went and got a letter from Miss Lane. She looked at the letter and immediately contacted the defendant to see if the letter's contents were true, and that ultimately led to her ultimate opinion.
Is there a request by a party right now to introduce a piece of evidence? I have simply only heard a discussion about who the expert has consulted with. I don't think that there is sufficient grounds at this point to sustain any objection, as the question was, did you speak with a Miss Lane? So the objection as to that question is overruled. Counsel, you may proceed.
Yes, Your Honor. Now, let's go back, actually. Let me go back. There were not enough similarities in the signatures, correct?
There were sufficient similarities.
But not enough to make a conclusive finding based on your signature analysis.
Yes, I would say that it was inconclusive, although it seemed genuine.
Exactly. In fact, you believe that it is possible that someone else signed the will.
That is a possibility, although it's not my ultimate conclusion.
But it's still possible.
I suppose it is possible.
So as an expert forensic document examiner, you cannot tell this jury, based on your signature analysis that we just went through and the notes that we just went through, that Mr. Donaldson signed this last will and testament.
I can say that it seemed genuine, and I recommended to my company to pay out the policy.
So you cannot say for 100% certainty that Mr. Donaldson signed this last will and testament.
Objection, Your Honor, asked and answered.
Overruled.
No, I would say that handwriting analysis does not come with 100% certainty.
Right, because to use your words, it is possible that someone tried to copy Mr. Donaldson's signature.
That is a possibility.
Okay. Now, the will produced by the defendant was allegedly witnessed by two people.
That's correct.
Let's talk about those witnesses. One of them was the defendant.
Yes, it was.
But the defendant was a beneficiary to the will.
That's true.
Actually, the defendant was the only beneficiary to the will.
Correct.
So obviously, the defendant had an interest in this will.
Yes.
And it is unusual for a beneficiary to be a witness to a will.
I don't know if I can speak to how unusual it is. It's not necessarily preferred, but it's also perfectly legal in this state.
Okay, Ms. Renard. As you have said, that is disfavored.
Correct.
Now, the other witness was Samantha Lane.
Yes.
And during your investigation, you received a letter from Miss Lane.
Yes. Well, first I actually spoke to Miss Lane in person, where she confirmed that she was there and witnessed the signing. And then after that, I did receive a letter. Yes.
Miss Lane told you that she did not witness Mr. Donaldson sign the will.
On your objection, counsel?
Your Honor, this is the renewal.
Response?
Your Honor, under Federal Rules of Evidence 705, I'm allowed to cross-examine an expert witness on things that she considered in forming her opinion. Renard considered the letter from Miss Lane in forming her opinion, whether or not it was brought up on direct or anything like that. And it does not matter if Mr. Renard disregarded the letter. And in fact, that is the purpose of Rule 705, to allow an expert to be crossed on matters that the expert rejected, and for the jury, in weighing the expert's opinion, to determine if that evidence should have been disregarded. It's a question of fact.
And specifically in regards to the hearsay objection?
Your Honor, Federal Rules of Evidence 705 is that it covers inadmissible evidence.
Right. At this time, understanding Rule 705 does allow the court or parties to cross-examine or direct an expert and look into their opinion based on materials they've looked at. It does require the proper foundation in order to reach that mark. So right now I'm faced with an objection as to hearsay. However, the plaintiff's response is that Rule 705 allows for them to cross-examine based on what the expert looked at. At this time, though, the court does not have in front of it enough foundation specifically that this expert witness did rely on all this information. I'm not saying that this evidence will not come in, but counsel, you're going to need some more foundation about how the expert came into contact with this evidence and how it was factored into her considerations. So I'm going to sustain the objection for now.
Your Honor, may I have a point of clarification?
You may.
Be heard outside the presence of the jury.
You may.
Okay. This letter, she was sent a letter. I think that I've already gone over the fact that she was sent a letter. Is okay. Actually, is that enough? Like foundation, or what exactly do I need to go over?
Counselor, you're going to need to elicit a little more foundation about the circumstances of the letter, specifically what the letter was regarded to, why she was provided this. I can't give you all the talking points you need for your cross-examination here, but just any more foundation would be helpful to the court in determining how this was factored into the expert opinion, because at this point, I don't have a direct tie from the evidence the expert received to how that was tied to her opinion.
Yes, Your Honor. Okay. Now, during your investigation, Ms. Lane told you that she did not witness Mr. Donaldson sign the will.
No, during my investigation, when I spoke with her, she told me she did witness him sign the will.
But the letter that you received said that Ms. Lane did not witness Mr. Donaldson sign the will.
Well, I was never able to confirm whether that letter was actually from Miss Lane, so I can't speak to that.
Okay. You did not talk to Ms. Lane.
Yes, I did talk to Miss Lane.
You did not talk to Ms. Lane after she sent you her letter.
After I received a letter that purported to be from Miss Lane, I attempted to contact her, but was unable to.
Exactly. You were unable to contact her because you could not find her.
Right, I was unable to find her and confirm whether she actually sent that letter.
And that was after you talked to the defendant.
Yes, after I received the letter, I first went to the defendant because, as the other witness, I wanted to know if she witnessed the signing of the will. And then from there, I did continue to try to reach Miss Lane, but was unable to.
Okay. And the letter told you, in the letter, it told you that Miss Lane was actually coerced into signing the will.
That is what the letter says.
Right. And you did not speak to Miss Lane about her letter.
We have an objection being raised. Counsel, on your objection.
I'm going to object again because it originally didn't come in and she's still kind of forcing and asking questions about it. I'm not sure why the line of questioning is continuing.
Counsel, you're going to need to move to admit this exhibit if you want to have any further questioning about the contents of that exhibit. It is improper to talk about the contents of any specific piece of evidence without it having first been admitted.
Yes, Your Honor. Plaintiff offers, plaintiff's exhibit. I'll move on. Okay. Now let's talk about.
Your Honor, move to strike pretty much everything that just came out about Samantha Lane and the contents of that letter.
I will move to strike the last question that happened after the objection was lodged. However, any questions that happened up until your objection did not have any type of contemporaneous objection alongside them, so that testimony will not be stricken.
Let's talk about the language in the alleged will. Not only was the defendant named sole beneficiary, she was also named sole executor.
Correct.
She was named sole executor if Mr. Donaldson should die or disappear.
That's correct.
You would agree with me that the language about disappearing is strange, right?
Yes, I reviewed several wills and that language is unusual.
Right. You actually found it suspicious for the will to contain any reference to disappearing.
Yes, you could say that.
You have been a forensic document examiner for 23 years, just like you said.
Correct.
You have reviewed hundreds of wills.
Correct.
And this is the first time you have ever seen the language, should I die or disappear?
Yes, the disappearance language, that was the first time I'd seen that specific language.
And Miss Renard, it just so happened that Lou Donaldson disappeared, didn't he?
Yes, he did.
No further questions, Your Honor.
Any redirect, counsel?
No, Your Honor.
All right. May this witness be excused?
Yes, Your Honor. Thank you.
Any further witnesses for the defense?
Yes, Your Honor. The defense calls Karen Baja to the stand.
You may proceed.
Could you please introduce yourself to the court?
Yes, my name is Karen Baja.
What do you do for a living, Miss Baja?
I run the Wild Wildlife Big Cat Sanctuary. It is my absolute passion to care for the animals there.
What is the Wild Wildlife Sanctuary?
It's a sanctuary for exotic cats, lions, tigers, leopards, the like. I have devoted my life for advocating and caring for these big cats.
How did you get involved with big cat advocacy?
My husband Lou and I shared a passion for big cats. We both loved them so much, and we worked together to build a legacy that is the sanctuary. Since I lost my sweet Lou, this is the greatest love that I have in my life.
I'd like to talk to you a little bit about your husband. How long were the two of you married?
We were married in 2001, so we had a little over 11 years together.
How did the two of you meet?
I was hitchhiking one night and he picked me up. I knew right away that we were soulmates.
Were there any difficulties in the beginning of your marriage?
Well, he was married to his first wife at the time, and there was a 20-year age difference between us, so we got a lot of slack for that, but we were in love and there was no fighting it.
Now, how is your relationship with his daughter, Cam Donaldson?
Well, we've never really gotten along that well, really. She never liked me.
Why don't the two of you get along?
She thought I was after Lou's money, but that's just because that's all she valued him for. She called Lou Green Thumb because of his ability to make money. I didn't care about that. I loved him for his spirit and his love of the big cats.
Were there any difficulties in your marriage, Miss Baja?
Of course, everyone has their issues.
Oh, what were the basis of your issues around the time that Mr. Donaldson went missing?
Well, Lou had a mistress in Costa Rica. It was something we had discussed and we were working through. I loved him and I thought we might be able to work through it. But then he disappeared.
Now, I'd like to direct your attention to August 17th and 18th, 2012. Did you see your husband at all during those days, Ms. Baja?
No, one of our tigers had cubs and had rejected them. And when that happens, they need round-the-clock care. So I was in our big cat nursery on newborn duty. I had been fully consumed with them for days, and they were doing so great, and they were so cute. But I honestly wasn't sure if Lou had been home, and I hadn't seen him the days before. I'd been so busy with these cats.
Was it normal for you to not be aware of your husband's whereabouts?
Oh, yes, he had several planes at different hangars. He would take off at a moment's notice, and he was very secretive, particularly at this time because his license was suspended. He didn't file flight plans, but he would always come back. Until he didn't.
Now, on the evening of August 18th, 2012, did you leave the big cat nursery at all?
Yes, I realized in the early morning hours that we had run out of milk and formula, and so I ran to the grocery store for supplies. On the way back, my car broke down.
What did you do then?
I didn't have my phone, so I flagged someone down for help, and then I called my brother to give me a ride back to those sweet cubs.
And what time was that, Ms. Baja?
A little after 3 in the morning, I believe.
When did you realize that your husband went missing?
On August 18th, and I reported him to the police missing immediately.
Now, if it was normal for you not to know where your husband was, why did you report him so quickly?
Like I said, I had been consumed with the cubs for days, so I wasn't sure how long he had been gone. I got worried, so I wanted to make sure that he was okay and to get the police's help.
Did you have any idea where he might be at that time?
Well, I thought we were working through our issues, so I didn't think he had gone to see his mistress in Costa Rica, but I knew it was a possibility.
Did you tell police about this possibility?
Yes, I wanted to give them as much information as possible to help track him down.
Now, did you go to Wild Wildlife that night, Ms. Baja?
Yes, I was so worried about Lou, and I didn't trust Cam. I wanted to make sure everything was fine at the office.
Did you damage the property at all to get in that night?
No, of course not. I had every right to be there. There would have been no reason for me to break into anywhere on the Wild Wildlife property. The lock and gate were fine when I was there. I don't know how or why they must have gotten mangled up that way.
Oh, were police there whenever you were there that night?
No, they weren't.
Now, did you make yourself available for police questioning after you reported your husband missing?
Of course, it's only natural that they would question his wife. There had been some crazy theories thrown out there by Cam as well.
Can you explain what you mean by that?
Well, once Cam realized that she wasn't getting her father's money, she started claiming that I was responsible for Lou's disappearance. Specifically, she claimed that I put his body through the meat grinder and fed him to the cats.
Now, Ms. Baja, are you familiar with an exotic Bob?
Unfortunately, he has hated me for years because he blames me for his being in prison and losing some of his cats. He would say anything to get back at me.
Now, you've been in the courtroom today.
Yes.
Is there any truth to the video that we saw from Exotic Bob?
Absolutely not. I would never work with him in a million years. I would never engage in illegal animal trade. My life's work is for advocating for these cats.
Now, is it possible to put a human body through the meat grinder on wild wildlife property?
I mean, I wouldn't know, but I suppose it would be possible. But I can't imagine anybody getting away with something like that.
Why is that?
It takes two people to operate the grinder, and it makes a huge mess.
Oh, did you make that meat grinder available to police for examination?
Yes, I did. I was completely open and cooperative with them. I wanted answers about Lou as bad as anybody, and I knew that they had to check all avenues.
Were you ever taken into custody?
No, never. As far as I know, the police cleared me as a suspect back in 2012, and then the insurance investigator cleared me again in 2017. I don't know why Cam is so set on accusing me when time and time again there has been no evidence that I did anything wrong.
Now, Ms. Baja, did you have your husband declared dead?
Yes. I prayed for years he would come home, but after such a long time, I realized that I needed some closure. The uncertainty of it all was just hanging over my life. And I will always love him, but I needed to find some kind of peace with it.
Now, I'd like to shift over to the subject of the inheritance that you received. Are you aware of the plaintiff's claims about the last will and testament?
Yes, I've been in the courtroom and Cam has been claiming this all for a while.
Now, are you aware of any prior versions of your husband's last will and testament?
No, there may well have been a prior will, but I never saw it if there was.
Ms. Baja, did the relationship issues you may have had with your husband ever affect your ability to work together at the sanctuary?
Not at all. Despite the issues that we may have had in our marriage, Lou and I had a soul connection when it came to the big cats and the wild wildlife big cat sanctuary. He knew that I would never let anything or anybody come before those cats, and that's what he wanted to, most of all. Anybody who really knew the two of us knows that he would have trusted me to continue protecting and advocating for the cats and to protect the legacy that is the wild wildlife sanctuary.
And Ms. Baja, what have you spent the money that you've inherited on?
It all goes towards the maintaining of the home for my big cat family, just like I know my sweet Lou would have wanted.
Ms. Baja, do you have any idea what happened to your husband?
I still pray that he is alive somewhere in Costa Rica, living his days out happily. I wish I had answers for Cam and for myself about why he left or what happened to him, but I simply don't know.
Thank you, Ms. Baja. No further questions at this time.
Cross-examination.
Yes, Your Honor. Ms. Baja, the night Mr. Donaldson disappeared, you claim you were at the grocery store?
Yes, ma'am. The cubs were on a strict feeding schedule, and unfortunately, we ran out of formula and milk, so I had to go to the store.
At 3 o'clock in the morning?
Yes, ma'am. Like I said, they're on a really strict feeding schedule, and it was late, but I had to get them their food.
And that same night, you just so happened to leave your house without your cell phone.
I know. I had been so tired these past couple of days. I don't know how I forgot it. It's just I'd been so consumed with the cubs. I guess it just slipped my mind.
And that same night, your car just so happened to break down.
I know. It's It's ridiculous, but it did. And my brother thankfully was able to come get me to return me to my sweet cubs.
And that same night, your husband just so happened to disappear.
Unfortunately.
When your car broke down, you didn't call your husband.
No, I didn't. I knew that my brother was working that night, and I knew he'd be able to return me to my sweet cubs, so I called him.
That's right. You called your brother.
Yes?
And your brother took you to Wild's Wild Life.
Yes, he did.
You have a meat grinder at Wild's Wild Life, don't you?
Yes, in order to feed the cats.
And that meat grinder, it is not small.
No, it's not.
That's right. It's massive.
I'm sure you could qualify it as massive.
As you have said before, it is so big, it takes 2 people to even use it.
Yes, ma'am, that's correct.
Ms. Baja, this meat grinder is big enough to dispose of a body.
I mean, like I said, I wouldn't know from personal experience, but I guess so.
Sure. Now, before Mr. Donaldson disappeared, you were having marital problems.
Every marriage has their issues, and unfortunately, yes, my husband had a mistress in Costa Rica.
Before Mr. Donaldson disappeared, he asked you for a divorce.
Yes, but we were working through our issues.
You did not want a divorce, did you?
No, I loved my husband, and of course I wanted to continue being his wife, and we were working through our issues.
That's right. You wanted to work things out.
Yes.
Ms. Baja, you went through a lot in your marriage, didn't you?
It depends on what you mean by a lot. I'm a little confused. Would you mind clarifying?
Sure. Your husband would leave you on several occasions.
Do you mean to go on like business trips, like to fly? I'm sorry, I'm still just a
Yes,
little.
Ms. Baja. As you have previously testified, your husband would fly back and forth to Costa Rica, right?
Yes, he would fly all the time.
And leaving you back home.
Yes, I was at the sanctuary taking care of the cats.
You didn't travel with your husband.
No, I didn't think that it was necessary.
And you didn't like your stepdaughter.
I didn't trust her and we didn't get along. She never really liked me.
And you had to work with her every day.
Yes, but we were civil to each other at the sanctuary.
But it's hard working with someone that you don't like. Would you agree with that?
No, we were adults and able to put our feelings aside.
Ms. Baja, let's talk about after your husband went missing. You didn't try to find your husband.
I personally did not investigate, but I did immediately report my husband missing to the police. I was worried about him and I trusted the police department to find him. So yes, I did try to find him by calling the police. I trusted the police in their investigation.
So Ms. Baja, you were claiming you're the one who filed a missing persons report?
Yes.
This is your first time testifying that you filed that missing persons report.
I believe so, but I did say that I was worried about my husband.
In your deposition, you never mentioned that you were the one who filed the missing persons report.
No, I did not say that in my deposition I filed the missing persons report.
Ms. Baja, you petitioned to have your husband declared legally dead in August 2017, right?
Yes, that is correct.
And you were granted your husband's entire estate by a will that you brought forward.
Yes, I was granted my husband's estate by the will that he created.
Your Honor, at this time, may I publish Plaintiff's Exhibit 2, which has already been admitted?
You may.
This will that you produced made you the sole executor of Mr. Donaldson's estate.
Yes, that is correct. Lou knew I loved the animals and I was his wife and we worked really well together.
Ms.
And so
Baja, I just need a yes or no.
I apologize. Yes.
This will you produced left you all of Mr. Donaldson's real and personal property.
Yes, that's what it says.
And you were also a witness to the signing of this will.
Yes.
And after Mr. Donaldson was declared dead, you inherited $5 million from this will.
Yes, ma'am.
And you inherited an additional $5 million from your husband's life insurance.
Yes, ma'am.
So, with Mr. Donaldson dead, you inherited $10 million.
My husband disappeared, but yes, at the end of the day, I did inherit $10 million.
Ms. Baja, you were the one who had your husband declared legally dead, correct?
Yes, and as I've said today, I had him legally declared dead because after years of hoping that he would return, I needed some closure for myself.
Ms. Baja, if your husband had divorced you, you would have received nothing.
Yes, that's correct.
No further questions, Your Honor.
Is there any redirect?
No, Your Honor. May this witness be excused?
They may. All right, are there any further witnesses for the defense at this time?
No, Your Honor. The defense rests.
All right, at this time, the court has heard both the plaintiffs and the defense's cases in chief. Before moving to closing argument, are there any issues the parties need to take up?
Your Honor, we would simply renew our motion from earlier on the same grounds.
Which motion are you referring to, counsel?
The motion for, judgment as a matter of law.
At this time, the court is going to stand by its previous ruling, understanding that in the light most favorable to the plaintiff, there has been enough evidence that a reasonable juror could conclude that the defendant did cause the disappearance and death of Lou Donaldson. Not saying that they should, simply that a reasonable juror could. Are parties prepared to proceed to closing argument, or do you need a brief recess?
Your Honor, could we get a time check quickly before recess?
Good idea. And our timekeeper, can we get an update, please?
Yeah, can we just have one moment to finish adding up times?
Absolutely, take your time.
Okay, so I have that the plaintiff has used 50 minutes and 7 seconds, and that the defense has used 44 minutes and 37 seconds. And that's out of their total of 70 minutes.
I'm confirming I'm within about a 15 to 20 second margin. So Chris's numbers are good.
All right. Are the parties prepared to proceed to closing, or do you need a brief recess?
If we could have maybe a 2-minute recess.
Sure, that works. Let's be back online here. Let's make it 3 at 6:16 p.m.
Thank you, Your Honor.
All right, we are back on the record in the Donaldson versus Baja matter. Are parties prepared to proceed to closing arguments?
Yes, Your Honor.
Yes, Your Honor.
Right. And prior to getting started with the plaintiff's closing argument, is there any request to reserve any time for rebuttal?
Yes, Your Honor. May I save whatever time is remaining at the end of my closing argument for rebuttal?
You may. Thank you for letting the court know. All right, and we can proceed to the plaintiff's closing argument. And before you begin, counsel, if opposing counsel and myself, we will disconnect video for your closing argument just so that you can have the screen, counsel, okay?
Okay. Thank you, Your Honor. When faced with losing everything, some people will do anything. When this defendant was faced with losing everything, she did the wrong thing. She killed her husband to keep her status, killed her husband to keep his business. She killed her husband to keep his money. The defendant's greed led to Lou Donaldson's death. The defendant's greed led to Cam Donaldson's grief. This defendant planned and intentionally caused the death of Lou Donaldson, and she does not deserve to get away with it. Now, the defendant had Lou Donaldson declared legally dead on August 18th, 2017. And as the plaintiff, we bear the burden of proving to you by the greater weight of the evidence that it was the defendant who killed Lou Donaldson. And we told you from the beginning that Mr. Donaldson's body was never found. But the defendant cannot get away with killing Mr. Donaldson just because she got rid of the body. We have proven by overwhelming circumstantial evidence that the defendant intentionally killed Lou Donaldson. And really, all circumstantial evidence is just common sense. It's like the man stranded on a deserted island for months, never seeing another living soul. One day, as the man's walking around on the beach, he sees a human footprint and he faints. Why did he faint? Because he knew what that footprint meant. He was not alone. You see, the man did not have to see the other person to know that he was no longer alone, because the footprint was circumstantial evidence. It's just common sense that another person was on the island. And that is why the judge will tell you that the law makes no distinction between the effect of direct evidence and of circumstantial evidence. And we have shown you 3 reasons why we know the defendant killed Lou Donaldson. First, the defendant's actions on August 19th and the days that followed. Second, the will the defendant produced. And third, the defendant's threats. First, let's take a look at the defendant's actions, starting with the early hours of Sunday, August 19th, 2012. Now, at 3 o'clock in the morning, the defendant claimed she was getting milk, but she just happened to leave her phone at home. So who does she call when her car breaks down? Her brother, not her husband. Why didn't she call her husband? She claimed she was not sure if he was home, but Cam told us that her father invited her to dinner that Sunday night. You see, Mr. Donaldson was not planning to go anywhere, not planning to take any trips. He was planning to be home. But the defendant did not even try to call her husband. Why not? Because she knew he could not answer. And then at 6 o'clock a.m., just a couple of hours later, Cam sees the defendant coming out of the office at Wild Wildlife with a man Cam did not know. Who was that man? It had to be the defendant's brother. She had just called him a couple of hours earlier. Now, why is it important that the defendant and her brother are together not only in the middle of the night, but also at Wild Wildlife before 6 a.m.? It's important because it takes 2 people to use the meat grinder at Wild Wildlife, 2 people to put a human body inside. You see, the defendant had the means to dispose of Mr. Donaldson, and she also had the help. You see, the The defendant knew that without her cell phone, her location could not be tracked. Nobody would know where she was for those 3 hours. You know who else could not be tracked for 3 hours that same night? Her brother. You heard in his testimony that the transponder in his vehicle just conveniently stopped working. Why? So nobody could track his location as they were disposing of Lou Donaldson's body. Most telling is the defendant's reaction when the police tried to question her. Y'all remember, "I'm the owner of Wild Wildlife. If you have any questions for me, you can contact my attorney." Why did the defendant lawyer up? What did she have to hide? Why not just explain to the police that you were out getting milk for your cubs and you just happened to leave your keys inside? Why not explain what was going on? Explain what you were doing. The same reason she's claiming to be the owner of Wild Wildlife before anyone even knew that Lou Donaldson was missing. Because this defendant, she knew that Lou Donaldson was dead. And she did not want the police snooping around that meat grinder. The defendant's actions in the days following that Sunday also proved that the defendant killed Mr. Donaldson. Now, the defendant came in here today and she claimed that she held out hope for 5 years that Mr. Donaldson would return. It was not even 5 days before she fired his daughter. And the defendant knew how close Cam and her father were, knew that they had worked together for 20 years. There is no way the defendant fires Cam just a few days after Mr. Donaldson disappears if she thinks there is any chance that Mr. Donaldson is going to walk back through that office door. She fired Cam because she knew she could. Because she knew Lou Donaldson was not coming back. Because she knew he was dead. That brings us to the second reason why we know the defendant killed Lou Donaldson, the will the defendant produced. This will left the defendant everything. And Cam, nothing. You see, this is not the will of a man who worked side by side with his only daughter for 20 years. This is not the will of a man who had his daughter, not his wife, handle all of his finances. This is not the will of a man who had the type of close relationship with his only daughter that we heard so much about today. This is not the will of a man who had a $5 million estate. No one worth that much money is going to run onto Google and Google legal Zoom forms, pull this one up and claim it's their will. This was not Lou Donaldson's will. This will is clearly a forgery. Chris Renard, the defense's witness, she told us that she could not determine if the will was a forgery, but admitted there were several differences on cross-examination. And she also said that her results were inconclusive based on the signature analysis. Now, really, we don't need an expert to see that this signature is not the same as Mr. Donaldson's known signatures. I mean, just look at them. Anyone can tell that this signature is not the same. But we did have an expert, Taylor Pride, and he confirmed for you that this will is, in fact, a forgery. We also know this will is a forgery because the defendant actually wrote that she would receive everything if Mr. Donaldson should die or disappear. And what do you know? That's exactly what the defendant is claiming today, that Mr. Donaldson just disappeared. Both Taylor Pride and Chris Renard told you that in the hundreds upon hundreds of wills they investigated, never once have they ever seen a will contain the language disappear. Of course they haven't. People write wills to plan for their death, not their disappearance. People write wills because everyone knows that they will eventually die. No one plans to disappear. And there's one more thing that proves this will is a forgery. Actually, everything about this will proves that the defendant killed Lou Donaldson. And that brings us to the final reason why we know the defendant killed Lou Donaldson: the defendant's threats. Cam told us that just 2 weeks before Mr. Donaldson disappeared, her dad again asked for a divorce, and that the defendant was furious, screaming, yelling, storming out of the office. Moments later, Mr. Donaldson came out of the office, upset, scared, shaking. Looking at Cam, his only daughter, Mr. Donaldson said, "If anything ever happens to me, be sure to have the police look into Karen. She will be responsible for my death." Now, why would he say that after an argument? It had to be because the defendant had threatened to end his life, to kill him. And she did. The defendant even admitted to Exotic Bob that she killed her husband and used the meat grinder to dispose of his body. So just like that footprint on the beach proved that the man was not alone on the deserted island, the defendant's actions on August 19th and the days following, the will the defendant produced, and the defendant's threats, and just plain old common sense prove that the defendant intentionally caused the death of Lou Donaldson. And in doing so, caused Cam Donaldson's injuries. Cam's injuries were far more than the loss of her inheritance. Cam lost the man she worked side by side with for 20 years, her friend, her father. The grief, pain, suffering, emotional, and even physical stress that comes with the untimely loss of a parent leaves a hole that can never be filled. Their absence is not only felt in holidays when you can expect for family to gather, but in the small moments. No more picking up the phone to call him. No more goodbyes when leaving the office. No more Sunday dinners. Cam will suffer these injuries every single day until her last. Now, the judge will give you this verdict form, which fines for Cam Donaldson and awards her money damages. Now, as much as we wish that we had a time machine so that we could go back in time and prevent this heinous act from ever being committed, we don't. And money damages are the way in which our legal system can provide compensation for Cam's injuries, for Cam's loss. Considering the size of her father's estate, we suggest that you award Cam at least $10 million. Because when faced with losing everything, some people will do anything. When this defendant was faced with losing everything, she did the wrong thing. She killed her husband to keep her status. She killed her husband to keep his business. She killed her husband to keep his money. Do not let her get away with this. Fine for Cam Donaldson.
All right, thank you, counsel. Any time is reserved for rebuttal. Do the defense have a closing argument they wish to proceed with?
Yes, Your Honor.
You may proceed.
May it please the court, counsel, members of the jury. We wish we had answers for the plaintiff about what happened to her father. We wish we could tell her exactly where he went on August 17th, 2012, and what happened to him. We wish we could explain his exact reasoning for giving his belongings to his wife instead of her. We're here today because, like so many of us do, when the plaintiff was faced with grief, confusion, and unanswered questions, she looked for someone to blame. But members of the jury, placing that blame on Ms. Baja for something she had no hand in won't give the plaintiff the peace she so desperately wants. Of course, the plaintiff wants to believe that Ms. Baja is the criminal mastermind behind every bad thing that has happened to her over the course of these past 8 years. Nobody wants to believe that their father would leave his estate to his wife instead of them, especially not when that wife is a woman 20 years younger than their father and was the reason that their parents' marriage split apart. This would be difficult for anybody to accept. So the plaintiff didn't accept it. Instead, she began concocting wild theories to try and explain away her father's actions that she couldn't reconcile. Now, soon, the judge will talk to you, and he'll explain that as a juror, it is part of your duty not to guess or speculate about a fact. So while the plaintiff has asked you to fill in the blanks about what happened to her father, it is your duty not to. Now, the plaintiff had the burden of proving 4 things to you today. 1, that Lou Donaldson is in fact deceased. 2, that if Lou Donaldson is deceased, his death was caused by the intentional or reckless conduct of Ms. Baja. And that also the plaintiff suffered injuries due to that death, and that those injuries were caused by Ms. Baja's conduct as well. Now, if you feel that even one of those elements hasn't been proven today, without having to guess or speculate about a fact, it's your duty to find Ms. Baja not liable. And members of the jury, the first blank that the plaintiff is asking you to fill in today is a big one. Whether or not Mr. Donaldson is even dead. Because as we learned today, we have no idea what happened to Mr. Donaldson. We know he disappeared, but we also know that he wanted to get out of his marriage. We know he had a mistress in Costa Rica. We know that he was a very wealthy, very eccentric, very secretive man who owned multiple planes. Now, because nobody knew how many he owned, nobody could have possibly known where he kept them all. But that's not all we don't know. Because while the plaintiff showed you one banking record that shows that Mr. Donaldson didn't touch an account after he disappeared, we have no idea what kind of offshore accounts Mr. Donaldson might have had, or what kind of assets he might have had waiting for him in Costa Rica. It was the plaintiff's burden to prove to you that he is dead. They didn't tell you about any signs of a struggle that were found, any evidence pointing to something sinister happening to Mr. Donaldson. We don't know that he's dead. Don't fill those blanks in for them. Because let's talk about the second element. Because Mr. Donaldson, we don't know for sure that he's dead, but that's not to say that we know for sure that he's alive either. We don't. Maybe Mr. Donaldson didn't intend to leave his wife and daughter forever that day. Maybe something else tragic happened to him that explains why Ms. Baja lost her husband and why the plaintiff lost her father. And we don't know what that is. But it was the plaintiff's burden to prove that if Mr. Donaldson is in fact dead, that death occurred at the hands of Ms. Baja. And if we're filling in the blanks here, we should think about the fact that Mr. Donaldson often hopped on a plane at a moment's notice without telling his family where he was going or filing flight plans. We know that he often traveled abroad for long periods of time. And we know that he was flying with an unregistered plane and his license was suspended at the time. So if we're filling in these blanks, isn't the most logical explanation that Mr. Donaldson hopped on a plane that evening, as he normally did, fully intending to be back by Sunday evening to have dinner with his daughter. But whether it be a problem with the plane, an issue with his vision, or some other issue that caused that plane to go down, some other tragedy may have occurred. Or maybe something sinister was going on here, just not with Miss Baja. You heard the witnesses today. You heard the testimony from Carl Bannister. Mr. Donaldson often flew to Central America for extended periods of time. He was paranoid. He didn't talk about what he was doing down there. We don't know what kind of activities Mr. Donaldson was involved in. And if he got mixed up with the wrong people, isn't it possible that they caused Mr. Donaldson's disappearance? Ask yourself, what evidence have we heard to exclude that theory? Absolutely none. So if we're coming up with theories about what might have happened to Mr. Donaldson, why not fill in the blanks with any of these other options? Just because these options don't give the plaintiff the money and business that she feels she's entitled to, doesn't make them any less likely to be true. And if we look at the rest of the plaintiff's theory that Miss Baja was involved in Mr. Donaldson's death, none of it really adds up. Because let's think about what it is exactly that they're alleging. That on the evening of August 18th, 2012, when Miss Baja was giving round-the-clock care to kittens, she somehow overpowered a grown man, killed him, disposed of his body, and drove his van to a random airstrip 40 miles away. This all occurred without leaving a single piece of evidence behind. Now, you heard the plaintiff today. When she saw Miss Baja at Wild Wildlife shortly after, she didn't have any injuries to her person. There was no sign of struggle anywhere. And the plaintiff wants you to believe this idea that Miss Baja was simultaneously a criminal mastermind that could get away with this crime without leaving any actual evidence, but then was still rash and sloppy enough to create all of this unnecessary suspicion around herself afterwards. Because let's talk about some of the choices that they are alleging that Miss Baja made after she supposedly killed her husband. They talked about this airstrip. And the plaintiff told you that her father never kept any planes at that airstrip, so there's no way that he left it there and fled to Costa Rica. But members of the jury, despite the fact that absolutely nobody knows how many planes Mr. Donaldson had and where he kept them all, it also doesn't make sense that Miss Baja, if she had killed him and was trying to make it look like he had fled, why would she have chosen a random airstrip 40 miles away? If she was trying to get away with this crime and make it look like he fled, wouldn't she choose an airstrip where he was known to keep planes? Now, they also talked about Mr. Donaldson's glasses and how they were found in his van, and they pointed to that as some kind of evidence that Mr. Donaldson didn't leave. They said that this was his only pair and that he wouldn't have flown without them. But members of the jury, for one, this is a man with multiple wives, multiple planes, and multi-millions of dollars, and they want you to believe that he didn't have a spare pair of glasses? Now, even if we put aside how ridiculous that is, again, why would Miss Baja, knowing this, leave them in his van if she was trying to make it look like he fled? It just doesn't make sense. They want you to believe that she pulled off this masterful crime and left no evidence, but then also created all of this circumstantial evidence that they keep pointing at. At sometimes, whenever there's no evidence for them to hold on to, that idea of her being a criminal mastermind is convenient. But when they have something that they want to point at, she's brash and sloppy and can't tell up from down. Now, if they had failed to prove even one element of their case today, that would mean a not liable verdict. But now we've seen that they have failed to prove the first two elements of their case today. And with that, the rest fall by default. Because the other things that they had to prove to you today were that Cam Donaldson suffered injuries because of Mr. Donaldson's death, and that those injuries were caused by Ms. Baja's conduct. And there was much discussion of Mr. Donaldson's last will and testament, which did leave his estate to Ms. Baja. Now, they pointed to the language in this will as some huge tell that Mr. Donaldson didn't write it. But members of the jury, he was an eccentric man. He may very well have used this language, particularly if he was planning on disappearing to Costa Rica with his mistress. And you heard that the insurance company had their investigator analyze this will. And she told you it was her expert opinion that this will was genuine. Now, the plaintiff hired her own expert, Investigator Pride, and we should take special note of when Investigator Pride was hired, because the plaintiff didn't hire anybody to look into these suspicions she had about Ms. Baja or concerns she had about her father at all until about a month before Mr. Donaldson's will would come into play and his life insurance policy would be paid out. But aside from the plaintiff's motives in hiring Mr. Pride, I'd like to talk to you about some of the specific things that he told you today. Because he told you that when he conducted his analysis, he collected 3 samples: a driver's license, a court record, and a letter from Cam Donaldson. But when he shared his conclusions about the signature on the will, it was only in reference to a comparison done between the will and the court record and the driver's license. There was not a mention of the letter from Cam until my co-counsel confronted him about it on cross-examination. Now, this letter was the only genuine signature that Mr. Pride received, and not a copy. And it came from the plaintiff herself, so why would Mr. Pride not use that in his analysis? Because these samples were cherry-picked to come to the conclusion that the plaintiff wanted to come to. If the signature on the note wasn't a match, why didn't we see it today? Why didn't Investigator Pride tell us the results of that comparison? Now, whenever you're weighing the credibility of the witnesses today, you should remember that Investigator Pride was hired directly by the plaintiff. When he conducted his investigation and when he testified today, he was on the plaintiff's dime. Investigator Renard, on the other hand, wasn't hired by either party to conduct her analysis. The only person that she had to answer to was the insurance company, and the only thing they expected her to do was get it right. She had no dog in this fight. But when it comes down to every single element, even the most basic fact of whether Mr. Donaldson is even dead, you can't reach the conclusions that the plaintiff wants you to reach without filling in blank after blank after blank with the answers that she wants you to fill in. The insurance company rejected those answers. The probate court rejected those answers. The police rejected those answers. So, when faced with losing everything, who really here is willing to do anything? Because the plaintiff is trying, as a last-ditch effort, to ask you, the jury, to fill in the blanks that none of the other agencies would. But filling in these blanks won't bring the plaintiff or father back. Finding Ms. Baja liable for something that she had no hand in serves no justice. Find her not liable.
Thank you, counsel. Is there any reply by the plaintiff?
Yes, Your Honor.
You may proceed.
The defense has tried to downplay this will the entire trial. Why is it important that the defendant forged this will? Because Mr. Donaldson's estate was worth $5 million, which gives the defendant 5 million reasons to kill Lou Donaldson. You see, the defendant knew Mr. Donaldson wanted to divorce her, and she knew that if he did, she wouldn't get anything. But if she killed him and forged a new will, she could get everything. And that's just what this defendant did. The defendant's threats, the defendant's actions the night Mr. Donaldson disappeared, and the forged will all proved the defendant intentionally caused Lou Donaldson's death. Ladies and gentlemen, the only blank was who killed him. And that blank was Karen Baja. Fine for Cam Donaldson.
All right, thank you, counsel. At this time, the matter of Cam Donaldson versus Karen Baja stands submitted to the court. Thank you all parties for your appearances and argument today. The court will take them under consideration, and hopefully our jury will have an answer for us in writing sometime soon. All right, if all the participants could just turn your video back on now. Are there any further matters that the parties need to address? Okay. I'll just tell you a little bit about myself here. I am a prosecutor in Arapahoe County, Colorado. So I typically handle felony cases, sometimes misdemeanors, but I'm in the courtroom doing this type of thing all the time, at least in a non-COVID era. That's where you'll find someone like me. I want to let you all know you did a fantastic job here today. What you did here is very similar to what people in my profession do on a daily basis. The way you do your direct examinations, your closing arguments, your openings, the way you're admitting and using your exhibits, all of that is something that we're doing every day, and you guys do it just as well as so many lawyers that I work with. You honestly probably have a better grasp on using stuff like Zoom to admit exhibits and publish those to a judge and a jury. That is something that people like myself and my colleagues are learning how to do on the fly right now. I actually had my first hearing like 2 weeks ago where me and defense counsel actually had to admit exhibits via Zoom and WebEx. And it's a huge learning curve, but the way it kind of seems is this stuff is going to be here to stay even once COVID kind of goes away. So this is awesome practice for you. You're kind of getting ahead of the curve. You'll be the people helping, senior partners at firms or your senior deputies at the DA's and PD's offices learn how to do this stuff. So keep doing this stuff. It was really impressive. Everyone did a great job. I'll have specific feedback on the scoring sheet for each of you. I've been taking notes. Unless any of you had any specific questions right now, I'll do any specific feedback on that form.
Thank you for your time tonight.
Absolutely. I love doing stuff like this. This is fun. All right. Well, good luck to all of you in the rest of your rounds. And thanks again for the great argument.
Thank you.
Thank you.
Take care, everyone.